If you're ready. Yeah. And
we haven't yet. I'm debating whether I want to listen to it or not. Then I'll just be in my mind, I'll be processing. Yeah, there was it.
Yeah, use your own judgment on it. Yeah.
I'm not too close to you here, am I? I'm not.
Not at all. No. I get the paper on top. Yeah. Yes. Good morning, everybody. Good morning. Very good. I want to welcome everyone to the fourth week of our consideration of the Eighth Amendment of the Constitution. I want to welcome all our members whom I spoke to earlier this morning, and I also want to say hello to the people who are watching us online and on RTE News Now. Fáilte. We are steadily approaching the conclusion of our consideration of the Eighth Amendment. This weekend marks the last weekend that substantive material will be presented to the Assembly. Our fifth and final weekend on this topic will focus solely on formulating, agreeing and voting on the recommendations we will present to the Houses of the Oireachtas. This weekend's Citizens' Assembly will be almost entirely dedicated to information, testimony and opinions brought to the Assembly via the submissions process. Later today, members will hear from women who have been directly affected by the Eighth Amendment. Tomorrow, 17 advocacy groups that made submissions to the Assembly will make oral presentations to the members. Now, a few words about today, Saturday. We begin the weekend with a number of discrete legal sessions. The purpose of these sessions is to clarify outstanding legal issues raised by members in feedback sessions and to provide an overview in a neutral way about the options available in law in relation to the Eighth Amendment. Emily Egan, Senior Counsel, will present the first of the legal sessions, and the topic is the role of Article 43, Section 3, Subsection 3 in medical and parental decision-making. Emily will be followed by John O'Dowd, a lecturer in law in University College Dublin, who will talk on this topic, the constitutional rights of the unborn within and beyond the Eighth Amendment. As I mentioned, the purpose of these sessions is to address the outstanding legal issues by members, raised by members regarding the Eighth Amendment, beyond simply the termination of pregnancy, concerning both the unborn and the parents. And I think it has to be acknowledged that the issues that will be addressed by Emily and John are difficult issues, but the important thing is that you, the members of the Assembly, get an overview of the whole situation. Then, on the next session, Brian Murray, Senior Counsel, will be joining us for a session focused on legal consequences of retention, repeal or amendment of Article 40, Section 3, Subsection 3 of the Constitution. This will be the first time that the citizens will engage directly with the possible legal options which they may consider. I hasten to add that I'm conscious that the members have continuously sought clarity on the legal position of the impact of the Eighth Amendment in certain areas and of possible consequences to the changes to the law as it currently stands. Legal clarity is very hard to achieve. The provisions of the Constitution, by their nature, are open to interpretation. There is not always uniformity or consistency in interpretation. But this morning we are seeking to present you with a balanced view of the case law. In other words, how the courts have looked at the issues in this area. The same caveat applies to Brian Murray's discussion on the consequences of retaining the Eighth Amendment, repealing it or amending it. And I just want to pause here just to say, and I'll be saying it later in the day, you will recollect that you were given a copy of Article 40 at the first meeting in November in your pack. And in fact, I asked Sharon to put it into today's pack again, because it's very important. What we're here about is Article 40, Section 3, Subsection 3. And you must bear that in mind. And I will be preaching on this later in the day again. But and bear in mind that Article 40, there are two add-ons to it in the 12th and 13th Amendment. The protection of the right to travel and the protection of the right to information. So bear that in mind. This is all about Article 40, Section 3, Subsection 3. This morning's proceedings on the law will mark the end of the facts-based material being presented to the Assembly. From there, we will move on to opinion and advocacy. This afternoon, we will hear personal stories of 6 women directly affected by the Eighth Amendment. I will explain the session in much greater detail after lunch, but for the moment, I would like to take the opportunity to sincerely thank each woman who has agreed to be interviewed and share her experience. Dr. Mary Ryan from Maynooth University, who carried out the interviews with each woman, will lead the session for us. She will provide us with the background as to how the women were selected and how the interviews were structured. I think this afternoon's session will be moving and emotionally challenged for all of us, but it is an essential aspect of our considerations. And Cúpla focal, as they say, about Sunday. Tomorrow's proceedings will consist of oral presentations from advocacy groups who, again, all made written submissions to the Assembly. We will hear from 17 groups out of a total of 121 that made submissions. We have attempted to accommodate as many groups representing various ideological positions and experiences as possible. I think it is reasonable to say that we were never going to be in a position to hear from every group, and that every group that made a submission. The members made their own suggestions as to which groups they wished to hear from, and with regard to their preferences, I identified the final 17 we would invite to present to us. I want to emphasise, and this is important, that all of the advocacy group submissions are available to read on our website, and I would want to emphasise that for our viewers outside this room. And the website is www.citizanassembly.ie. In order to accommodate such a large number of groups, Sunday's proceedings have been extended to 4 p.m. I know this was a huge ask of the members, who already have dedicated so much of their free time to the task they've been given. I'm most grateful that they agreed to the extension, which will allow us to hear so many different perspectives. Without their dedication, it would not be possible to do this challenging topic justice. One of our key principles is respect, and to date, this principle has been adhered to. I would ask everyone to bear this in mind over the course of the weekend, particularly if presented with an opinion one may not necessarily like or agree with. So I want to emphasise respect. And I'm now going to call on Emily Egan, Senior Counsel, to begin this morning's session.
Good morning. I'm going to speak with you this morning about the role of Article 43.3 in medical and parental decision making. When it comes to medical decision making, there is a potential for a tension between the rights of a pregnant woman and the right to life of the unborn. At the outset, I'd emphasise two preliminary points. Firstly, that although Article 40.3.3 is most commonly discussed in the context of abortion, it's important to recognise that the wording of the article is actually very general. Rather than establishing a constitutional prohibition on abortion per se, the article establishes a constitutional recognition of the right to life of the unborn. And because the article is phrased in this way, it has implications beyond the concept of abortion. The second preliminary point I'd make is that the unborn may enjoy rights other than the right to life. For example, the case law has mentioned the right to bodily integrity or the right to personal dignity. However, it's very difficult to see how the courts will proceed in balancing those rights of the fetus other than life against the mother's rights. I would say in this regard that the Attorney General and X case does not apply to situations in which a balance is to be drawn between the rights of the woman and the rights of the fetus other than life. So, to consider, for example, the position of a woman who decides to use heroin during her pregnancy. In this instance, while there may be no risk to the life of the fetus, there could be a risk that the child, if born alive, will have developmental problems and that their health could be affected in quite a significant way. In a case such as this, where there's a conflict, therefore, between the right of the woman to autonomy and privacy and the right of the fetus to bodily integrity. Neither Article 40.3.3 nor the X case would appear to govern the result of this particular conflict. I want to speak with you briefly now about the right to refuse treatment, medical treatment, in general terms. And I would make a few introductory remarks in relation to that. The right to refuse medical treatment is a very important right as a matter of medical ethics and as a matter of law. It is protected in Ireland under the common law and also protected by the Constitution. The Medical Council's Guide to Professional Conduct and Ethics emphasises that every adult with capacity is entitled to refuse medical treatment and that a doctor must respect their patient's wishes, even if they don't agree with them. Furthermore, the National Consent Policy provides that if an adult with capacity makes an informed decision, this decision must be respected, even if it could result in the service user's death. There are some limitations on the right to refuse medical treatment that have been contemplated by the courts. For example, in the case Reaward of Court, withholding of medical treatment, Judge Denham postulated that the right could be infringed in the cases of contagious diseases, medical emergencies, or perhaps where the patient was unable to communicate. It is important, though, to emphasise that the right to refuse treatment includes the right to refuse life-saving treatment, and this has recently been recognised in the context of a prisoner on hunger strike. And of course, it's also important to remember that the right to refuse treatment extends to the right to take decisions which might be viewed as objectively irrational. So, I want to talk for a moment about issues that arise in relation to the refusal of treatment, medical treatment, during pregnancy. So the question which arises is whether Article 40.3.3 means that a woman's right to refuse treatment is limited during pregnancy, where the treatment may be necessary to protect the unborn. At the outset, it's important to distinguish between two separate circumstances. The first is where the treatment is necessary to protect the life of the unborn, and the second is where the treatment is necessary to protect the health but not the life of the unborn. Now, it's not at all clear that Article 40.3.3 has any application in a case for restricting the woman's right to refuse treatment by reference to the need to protect the health of the unborn. This is because Article 40.3.3 mentions only the life of the unborn, and also because of the very high constitutional status placed upon the right to refuse treatment. By contrast, however, it is arguable that if treatment is necessary to safeguard the right to life of a fetus, then Article 40.3.3 might require that treatment be provided in the absence of a woman's consent. HSE and B provides an example of how these issues might play out in practice. So, in the case of HSE and B, the High Court considered an application by the HSE for an order forcing a pregnant woman to have a caesarean section against her will in order to vindicate the right to life of her unborn child. Now, the medical evidence provided by the HSE was that if she tried to deliver the baby naturally, there was a real risk of uterine rupture, which could lead to the death of the baby and the death of Mrs. B. In fact, the risk of uterine rupture was estimated as 1 in 10. Therefore, Mrs. B was strongly medically advised that she should have an elective caesarean section, rather than attempting a natural delivery. In the course of the judgment, the court stated that it couldn't understand why Mrs. B would want to take such an unnecessary risk. However, the court accepted that its role was not to say whether it agreed or disagreed with Mrs. B's decision, but rather to decide whether she could be forced against her will to submit to a surgical procedure in the interests of her unborn child. The court acknowledged that if she were not pregnant, it would be a gross violation of her rights to forcibly restrain her and subject her to a surgical procedure to which she did not consent. Ultimately, the court decided to refuse the requested order for a caesarean section. In so doing, the court adopted the test for state intervention, which applies in relation to parental decision-making. Effectively, what the court said is that even in respect of a decision which can put at risk the health or life of a child, the courts would be very slow to intervene, and that this would only occur in exceptional circumstances. The court said that therefore, as the right of the courts to intervene could not be any higher in the case of an unborn child than in the case of a born child, the sufficiently exceptional circumstances which might justify interference did not exist in the case. It is important to emphasise, though, that in the HSE and B case, the medical evidence indicated that it was by no means a certainty that the fetus's life would be endangered by a natural delivery, although it was accepted that it carried significant risks. It does remain possible, therefore, that in a subsequent case, a court could take the view that Article 40.3.3 requires compulsory caesarean section, especially if there is a higher degree of risk to the unborn. I'd like to address you briefly on maternal brain death. In general medical terminology, the death of a person is equated with the death of the brain. We say someone is dead when they are brain dead. And a person may be brain dead, but nonetheless maintained on a ventilator. Now, the case of PP and HSE deserves some attention. In that case, the High Court had to consider the case of a woman who'd suffered a brain injury during pregnancy. She died on a ventilator and was diagnosed as brain dead. the fetus was approximately 15 weeks gestation and still had a heartbeat. It was accepted that the absolute limit for fetal viability was about 22 weeks, but that a fetus born alive, even at that stage, would have very significant long-term disabilities. The court considered an application by the patient's father. The patient's family wished that life support could be discontinued, and the court had to consider whether or not this was permissible. In that particular case, the evidence of the doctors before the court was that the prospect of a successful delivery, even if life support was continued, was virtually nil, and that therefore it would be futile to continue with the life support. Therefore, the order was not granted, because the court felt it was in both the best interests of the unborn and in the best interests of the woman to allow her to die, and to allow the fetus to die as well. However, it's important to emphasize that this is because there was no reasonable possibility that the baby would be born alive, even if life support was continued. In the course of the judgment, the court had to consider whether or not the patient, as a dead person, continued to enjoy constitutional rights. The court held that she did continue to enjoy the right to dignity and proper respect for her autonomy, and that due regard had to be had to the grief and sorrow of her family. However, the court also found that all of these rights were subordinated to the right of the fetus to life. The result of this case seems to be that in a future case, if a fetus is viable, an argument could be made that treatment should be maintained. This might cause difficulties in cases where continued life support would be strongly opposed by the family. I want to look now at the issue of a pregnant woman's right to elect to undergo treatment. And by this I mean treatment which is medically indicated for the woman but may have a detrimental effect on the fetus. And a well-known example in this respect would be where a woman was suffering from cancer and required chemotherapy, which might constitute life-saving treatment for the mother, but could pose a risk to the life of the fetus. On the wording of Article 40.3.3, it is arguable that the state would be required to protect the life of the fetus if the woman's election of treatment resulted in a threat to that life. In principle, it would seem that this particular situation is capable of triggering the test set out in the X case. As you'll recall, the test set out in the X case was that if it is established as a matter of probability that there's a real and substantial risk to the life, as distinct from the health of a mother, which can only be avoided by termination, then such termination is permissible. The same reasoning would seem to apply to medical treatment, one effect of which may be to terminate the pregnancy, where there's a real and substantial risk to the life of the mother if she does not undergo the relevant treatment. In this regard, I would also like to draw your attention briefly to the Protection of Life in Pregnancy Act 2013, which I know has already been the subject of other papers. Just to emphasize briefly that the purpose of this act was to codify the balance to be struck between the right to life of the mother and the right to life of the unborn, as set down in the X case. Now, the 2013 Act is drafted in broad terms and extends beyond a situation in which a woman simply makes a request for an abortion on the basis of a real and substantial risk to her life. Because of the way in which the Act is worded, it appears to apply to procedures which could have the result of ending the life of the fetus, or procedures in the course of which the life of the fetus might be ended, rather than merely to procedures which have as their purpose the termination of the life of the fetus. It seems, therefore, that the 2013 Act may well apply to the chemotherapy example that I've outlined above. Now, as you're aware, the effect of the 2013 Act is to allow such a medical procedure to proceed where there's a real and substantial risk to the life of the mother, and this is certified by 2 medical practitioners, or 3 medical practitioners if the risk to the life is posed by the risk of suicide. The 2013 Act, though, does refer to the need to preserve the unborn life as far as practicable. And this raises 2 separate possibilities. Firstly, that where life-saving treatment is required by the mother, the decision may be made instead to opt for early delivery of the fetus or baby if that's possible. The second possibility is that it might be argued that a doctor would be required to consider the possibility of delaying treatment until the end of the pregnancy, even if this might have a consequential detrimental effect on the health of the woman. I'll make a few remarks now in relation to capacity to consent to medical treatment and access to abortion by people who lack capacity and by minors. Now, historically, the law in this country took a status-based approach to capacity. That meant that a person's legal capacity was defined by reference to the category to which the person belonged. So if a person had a mental disability, they were therefore held to be legally incompetent to make decisions about their own treatment. Today, however, the law favours a functional approach to capacity. And by that I mean that the assessment of capacity is made by reference to a person's ability to make a specific medical decision at a specific time. So, for example, even though a person might have dementia, they may be able to fully understand a particular medical decision and make a reasoned decision for themselves, and this decision would be respected. This test of functional capacity was recognised by Judge Laffoy in the High Court in the case of Fitzpatrick and FK. Now, under the Assisted Decision-Making Capacity Act of 2015, decisions in respect of people who lack capacity are generally made on the basis of that person's will and preferences, beliefs and values. In the case of a pregnant woman who loses capacity, treatment decisions are made by the medical practitioner acting on that basis. A medical practitioner is required in this regard to consider the best interests of the woman in the absence of the best interests of the fetus and the best interests of the woman. I'd like to touch briefly on the capacity of minors. It is thought, and likely, that children or minors over the age of 16 may be legally competent to consent to a medical procedure which would lead to the death of a fetus, subject, of course, to satisfying the conditions laid out in the 2013 Act. Children under the age of 16 are in a different position. They do not enjoy any statutory right to consent to treatment, and the decision will be those of their parents. Now, in the United Kingdom, there is a line of case law to the effect that if a minor is sufficiently mature, they may enjoy a right to consent to treatment. That line of authority has not been followed yet or considered yet in this jurisdiction, and it is important in this regard to acknowledge that there is a distinction between Ireland and the UK in that the Irish Constitution strongly protects the rights of parents to make decisions regarding their children. Now, if a child is in long-term state care, the rights of the parent to consent or refuse to medical treatment are enjoyed by the state, which is in loco parentis. This was recently considered in a case A and B and the Eastern Health Board. That case concerned a child who was pregnant as a result of rape and who was in state care. She wished to go to England to obtain an abortion. Her natural parents originally supported the decision, but then sought an order, but then became opposed to the decision. Ultimately, the health board sought an order that would permit the child to go to England to undergo an abortion. The court, in looking at this issue, decided that it did not have jurisdiction to permit a woman to travel to another country to obtain an abortion that would not be legal in Ireland. Instead, the court said that the X case merely prevents injunctions being granted to prevent such persons travelling, but doesn't confer a positive right to travel. In this particular case, the court held that the criteria set out in the X case for abortion were satisfied in any event because there was a risk of suicide which posed a real and substantial risk to the child's life. Notably, this decision appears to have been made on the basis of the evidence of one psychiatrist. And on the basis of the 2013 Act, more evidence would be required for that same decision to be reached. I would like to close by offering you one remark in relation to the possibility of fathers' rights in the context of abortion. Article 40.3.3 makes no mention whatsoever of the father of the unborn. There doesn't appear to be any case law to suggest that the father may have any specific rights in relation to abortion. And furthermore, Article 40.3.3 preserves the mother's right to travel and doesn't say that it is limited in any way by the previous article. It might be argued, therefore, that this suggests that a father would have no entitlement to prevent a woman travelling abroad to obtain an abortion. On the other hand, however, it is likely that a father would be in a position to take proceedings and to access the courts to seek to protect the fetus from an unlawful threat, such as an illegal abortion. However, in those circumstances, the father would be accessing the courts to protect the right to life of the fetus, not necessarily to protect his own rights. I'd like to just close by referring to the fact that the cases that I've outlined to you do breathe some life into the bare bones of the legal principles. However, they have to be looked at with some caution. Many of these cases were decided in the context of emergencies, where legal arguments and the court judgments were completed very quickly. In addition to that, the fact that many of these cases were not appealed past High Court level does somewhat limit their precedential value. So in many respects, we are still in uncharted seas. Thank you.
Thank you very much, Emily, for a very interesting presentation. And I just want to draw the members' attention to the paper you got. It's a little bit broader than that, than the oral presentation, and there's a lot of valuable material in it, and I would strongly urge you to read the paper and try to understand. It's not easy for non-lawyers to understand these issues, but I would strongly urge you to read the paper. It's very useful to have it. And now we're going on to another difficult topic, and John O'Dowd is going to present to us.
Thank you very much, Judge Lafoy, and thank you very much to the members too for the invitation to address you today. So what I'll be talking about today is the question which came back from you, the members, about how exactly the unborn is defined, what the scope of that concept is, and also the related issue of what rights the unborn has beyond the right to life, or perhaps rights that are necessarily implicit in the right to life, such as the right to be born in a healthy and normal condition, as it's been described by Mr. Justice Cook in one case. And I want to stress, as Emily has already, that many of these are unresolved issues. They haven't been addressed by cases, and what we have to do is to try and draw out implications from the decisions the courts actually have made about the factual situations that have been presented to them. And the main case we need to grapple with in that regard is the case of Roach v. Roach, which, as the Supreme Court itself was at pains to point out, and Mr. Justice McGovern had been in the High Court as well, was not a case about abortion. It was a case about assisted reproduction. It was a case about the status of embryos that had been created outside a woman's body and not yet implanted into a woman's body. And so the case, Roach v. Roach, makes a decision about the relevance of the Constitution to that situation. Certain statements are made that might be relevant to the status of a fertilized ovum within a woman's body, created naturally, for example, but such statements are just what lawyers call obiter dicta. They are just statements of opinion by the judges, because that's not the case that they were deciding in Roach v. Roach itself. And I want to say a little bit about this question that you've raised about rights other than life, as to what range of protection is given, whether by Article 40, Section 3, subsection 3, or by some other provision of the Constitution in relation to the other rights and interests that exist before birth. So first of all, I want to say a little bit more about this notion that some things that judges say in cases are binding on later courts. So some things that are said in a judgment of the Supreme Court, the High Court and the Court of Appeal then have to follow in future cases that raise the same issue. But other things that the Supreme Court says are just by the way. They're just explanations the judges give as to why they've come to their specific decision, but they're not considered to be part of the basis of the decision itself. Therefore, they're not binding on future courts, or lower courts in particular. So not everything a judge says in his or her decision is binding on later judges. And the key issue normally in a case for identifying whether something is binding or merely an expression of opinion is whether what the judge said actually made a decisive impact on the outcome of the case. Would the case have been decided differently if the judge had thought otherwise on the particular issue where he or she has expressed an opinion? And everything else really that isn't decisive for determining which side wins in that particular case is generally regarded merely as an expression of an opinion by the judge. And I'll come back to how that distinction works in practice by reference to Roach and Roach itself. So in relation to the unborn, there may be two related questions here. Certainly that's the way this was treated in Roach, which is the question, the general question of when does human life begin? So there might be a general issue. The Constitution protects human life, therefore you have to determine when that human life comes into existence. And then there might be a more specific issue as to what the particular phrase, the unborn, means in Article 40, Section 3, subsection 3. So Article 40, Section 3, subsection 3 talks about the right to life of the unborn, ceart na meo gan bre, con amaha. So the right of the living who have not yet been born to their life. And judges have expressed different views about whether those are really the same issue or they're two distinct issues. So in Roach v. Roach, Mr. Justice Murray, the Chief Justice as he was then, said really the issue isn't so much about the meaning of the term unborn in Article 40, Section 3, subsection 3. It's about whether we can say that human life has already come into existence in this condition that occurred there, that a woman's eggs had been extracted from her body and they'd been fertilized outside her body and embryos had been created in that way. So for him, the key issue was, did human life already exist? Because in his understanding of it, all the Eighth Amendment did was to make it clear that the same protection of human life that applies to everybody who's been born also applies to before birth. So from his point of view, all you had to do was determine when human life began. But I think it's clear that the other four judges in Roach felt that it really was a question of interpreting, the issue they had to decide at least, was a question of interpreting what the phrase the unborn means in Article 40, Section 3, subsection 3. So they didn't really enter into that wider question, that more fundamental question of when human life begins. And there are a number of possible starting points where a human life or the unborn could come into existence which had constitutional protection. One of them is fertilization, obviously, where the sperm and the egg are brought together and, loosely speaking, conception takes place. This is certainly what the pro-life amendment campaign wanted in 1982-83. This is what they proposed, that there should be a constitutional amendment that said explicitly that the right to life started at the point of fertilization and continued thereafter. That's not the amendment that the government responded with. That's not what the Eighth Amendment said on its face. And also, if you talk about fertilization, well, there might be a difference between an egg being fertilized in vitro outside a woman's body and an egg being fertilized within a woman's body. So, as we'll see with Roach v. Roach, it doesn't necessarily follow from saying that because fertilization has occurred outside a woman's body, and that isn't human life, or that isn't the unborn, that the unborn mightn't come into existence at the point of fertilization when that happens within the woman's body. You might draw a distinction between those two things. And then also in relation to implantation, the other key phase that's identified in Roach v. Roach is implantation. Again, a distinction, the same distinction basically, could be drawn between the two senses of implantation. Because in Roach v. Roach, the implantation the judges were talking about is where an ovum has been fertilized in vitro and an embryo has been cultured for a few days and is then implanted through a catheter into the woman's womb. So that's an implantation procedure, a clinical procedure which is carried out by fertility doctors. On the other hand, there's the sense in which implantation occurs in the natural process of gestation, because fertilization takes place at one end of the fallopian tube, and then the developing human life travels along the fallopian tube and implants a little bit over a week later in the wall of the uterus. So a decision that there's no unborn, or there's no human life before implantation in the Roach and Roach sense, doesn't necessarily mean that the same conclusion must be reached in relation to the natural process of gestation, but I'll come back to that in a moment. And then there's also a possibility which is raised by Mr. Justice, the Chief Justice's decision in his judgment in Roach v. Roach, which is that maybe the unborn only comes into existence sometime, or human life only starts sometime after implantation has occurred. But again, it seems unlikely that the courts will find that there's any point after implantation in the wall of the womb, which is the starting point of the unborn. Because it's not clear when. Clearly, any idea that viability, that the ability of the fetus to survive outside the woman's body is a decisive point, that's clearly rejected by the Eighth Amendment. If you introduced viability as defining when the unborn came into existence, you'd really be negating the whole purpose, the evident purpose of the Eighth Amendment, which is to emphasize the right to life exists even when that life isn't capable of independent existence outside a woman's body. So it seems highly unlikely the courts would find a later point than implantation which they would use to define that. So if we look at this question of the stages of reproduction, you can see here that in the natural process of gestation, fertilization takes place near the ovary, at that end of the female reproductive tract, and then there's a period of several days during which the fertilized ovum is developing, going through various developmental stages, and then finally about day 8 or day 9 it implants into the wall of the womb. So we could say implantation has taken place in those circumstances. I mention this because this is not the situation, this is not the factual situation that the Supreme Court was considering in Roach v. Roach. That's not the case they had before them. They weren't being asked to determine anything in relation to that. What they were being asked to decide was when an ovum has been fertilized in a petri dish outside a woman's body, and the embryo has not only been allowed to develop for a few days, but then frozen and placed into storage for some indefinite period of time, and then it's thawed out and it's clinically introduced into our womb through a catheter, whether the unborn exists before that medical procedure has been carried out. And they say that in this situation, using that particular method of assisted reproduction, there is no unborn until the implantation takes place. But while that might have implications for what happens within a woman's body during the natural process of gestation, it doesn't automatically follow that future courts will consider themselves bound to reach the same conclusion. So it might be that the unborn does exist at the point of fertilization when the fertilization takes place within the woman's body. I'm stressing that because that's a question of what Roach decided. Now, it's a different question what the courts would be likely to decide if they were presented with this other question. Now, the other question, of course, so to recap on Roach v. Roach, the decision was an embryo created outside a woman's body is not amongst the unborn. Article 40, Section 3, subsection 3 does not apply in that situation. That's clearly what the court decided in Roach v. Roach, and that is binding on any High Court judge or any Court of Appeal judge. In a sense, it's also binding on the Supreme Court, and they'd have to find special reasons for refusing to follow that themselves in a future case. But they gave different reasons for reaching that conclusion. They had different ways of reaching that result. So for Chief Justice Murray, his key concern was that really it's not possible for a judge to say when human life begins, within this context at least. That's a question on which there are very profound philosophical disagreements. There are no legal criteria which would enable one to say, yes, human life has come into existence, or no, human life has not. Now, as I mentioned in the paper, of course, he was quite keen to point out that you couldn't say that at 3 months gestation, for instance, there wasn't a human life. So he thought that after a certain point, it becomes self-evident, it becomes indisputable that a human life has come into existence. But he felt that point doesn't occur before implantation in the context of the type of assisted reproduction procedure that was being carried out in Roach v. Roach. On the other hand, the other judges, 3 of the other 4 judges very explicitly say the reason why these embryos that were created outside a woman's body as part of a process of assisted reproduction are not the unborn is because the unborn only comes into existence when implantation in the womb has occurred. So the unborn only exists once it's within the womb and it's implanted in the wall of the uterus. And since that is a restrictive definition of the unborn, the particular facts of Roach v. Roach couldn't come within it. Now, that's the reason they gave, that's the reason they had for reaching their decision, but it seems fairly clear it's not necessarily binding on later courts because it wasn't the issue they had to determine. Now, what are the practical consequences of this? Well, one practical consequence perhaps is in relation to emergency hormonal contraception, commonly referred to as the morning after pill. So Levenel, I think, was the first product that the Irish Medicines Board authorised for sale. In 2002, I think the authorisation finally came through. So one of the issues is about emergency hormonal contraception, and also there may be issues, although it seems less applicable, there may be issues in relation to intrauterine devices as well, IUDs. Because the argument made here is that if emergency hormonal contraception or an IUD operates to prevent the implantation of the developing entity into the wall of the womb, then that constitutes the destruction of the life of the unborn and is therefore contrary to the right to life of the unborn. So if the unborn exists, if we go back, if we backtrack, I think we can, can't we? There's the back arrow. If we go back to the diagram, if the unborn comes into existence there on day 0 at the time of fertilization, and it already exists and it has constitutional protection, then if the morning after pill acts not just to prevent fertilization, but to prevent the implantation of a fertilized ovum in the wall of the womb, then that would constitute a violation of the right to life of the unborn if that fertilized ovum in the 8 or 9 days or so that it takes before implantation is the unborn. So that's the practical effect, that's the practical consequence of the decision the Supreme Court was taking in Roach v. Roach. But again, of course, they weren't considering a case of the morning after pill. That wasn't the factual situation before them. So while their opinion as to the reason they gave for their decision might have implications for that, it's not actually part of the binding decision. Now, it should be said that there's some disagreement about how often the morning after pill does operate so as to prevent implantation. If it prevents implantation, it does so incidentally because of a thickening of the mucus on the wall of the uterus. So the main purpose of the morning after pill is it's a hormonal contraceptive, but it might, as a byproduct, also in some cases where fertilization has already taken place, prevent the fertilized ovum from implanting. So the significant here is that if the unborn exists within a woman's body before the natural process of implantation, then the legality of the morning after pill or intrauterine devices would be in doubt. Now, at the time of the 2002 referendum, for example, the proposal there to put the criminal law in relation to abortion on a constitutional footing and to remove the suicide clause from the X test, that proposal was very clearly one for legislation that would confine the criminal law to unborn life within the womb. And that was one of the arguments made by its proponents, that as well as getting rid of suicide as a ground for termination of pregnancy, it was also clarifying that the criminal law, at least, wouldn't apply so as to prohibit the morning after pill, to prohibit intrauterine devices. But of course, that was an unsuccessful proposal, so that wasn't adopted in 2002. But one thing to note is that, of course, both forms of the morning after pill and intrauterine devices are authorised for sale in Ireland. The Irish Medicines Board decided to authorise Levenel firstly for sale in 2002. In 2011, it decided that such products could be dispensed without prescription in a pharmacy. Now, a challenge to this was mooted. A group announced in a press release that they were going to take a judicial review in the High Court of the Irish Medicines Board's decision to authorise Levenel on the basis that it was a violation of the right to life of the unborn, but that case has never actually occurred, so we don't have any decision on that particular question. And the other point to note is that the Protection of Life During Pregnancy Act 2013 is very specifically and clearly limited to unborn life within the womb. So the morning after pill, taking the morning after pill cannot be a criminal offence under the 2013 Act, because the 2013 Act makes it clear that the unborn life that it protects is just the unborn life that exists within the womb. And it seems most likely that that aspect of the 2013 Act is based on the assumption that the views expressed in Roche v. Roche do in fact represent the law. They represent what the Supreme Court ultimately would be likely to decide if that question arose. Because it's important to emphasize that in Roche v. Roche, at least 3 of the judges referred with approval to an English case called Smeaton, which I've mentioned in the paper, and Smeaton made the point that the old offence, the one that existed under Section 58 of the Offence Against the Person Act 1861, for example, was doing something with intent to procure miscarriage. And what Smeaton said was, you can only intend to procure miscarriage once there's already carriage, once the woman is carrying a fetus or developing life in some sense. And the English courts decided, well, the morning after pill can't be affected by Section 58, which is still in force in England and Wales. It can't be affected by Section 58 because before implantation in the wall of the womb, there's no carriage of a developing human life by the woman, which could consequently result in a miscarriage. And 3 of the judges in Roche, the majority of the judges, specifically approved that and say that's the correct interpretation of Section 58. And also there's an element in Roche of saying, well, the purpose of the 8th Amendment was to copper fasten Section 58 and 59 of the 1861 Act. So they're aligning the scope of the constitutional protection with the criminal law as it existed in 1983 and saying it really doesn't go any further than would be necessary to put beyond constitutional challenge and prevent the Oireachtas from repealing the provisions of the 1861 Act. But as Emily has pointed out, the 2013 Act is somewhat different in that it has a wider notion of what is involved in destroying unborn human life, but at the same time it restricts that specifically to unborn human life within the womb. And also, I suppose I should say, because Emily mentioned the question about medical treatment, it also has some implications for ectopic pregnancy, of course, because if the fertilized ovum becomes attached to some other part of the woman's body outside the womb, it seems likely on the basis of Roche v. Roche that that is not the unborn. So you're normally talking about a tubular ectopic pregnancy. That's very straightforward. There's broad agreement on how you treat that. But it would seem that a tubular ectopic pregnancy after Roche v. Roche doesn't involve consideration of treating it, doesn't involve consideration of Article 40, Section 3, subsection 3, because if it's correct that the unborn only exists within the womb, there is no unborn in the case of a tubular ectopic pregnancy. But there could be other cases, but we won't go into the details of that. So the other question that you want to know about, well, what other rights might the unborn have potentially outside Article 40, Section 3, subsection 3, or maybe another related version of that is what's the scope of the right to life that they do have under Article 40, Section 3, subsection 3. So it's true, and it's been noted in several of the cases dealing with this, that there are many laws that give children rights by reference to things that happened before they were born. So if you are in the womb and your mother is in an accident, for example, and she's injured and you're injured as well, and you are born and you have an injury as a result of something that occurred before you were born, you're entitled to sue somebody, just as though the injury was caused to you after birth. But one thing to note is that generally all these are statutes that deal with what the position of a child is once the child has been born, with reference to what happened to the child before it was born. If there is no live birth, generally these provisions don't apply. They're about determining the rights of the child after birth in relation to what happened before the birth took place. And so they don't directly generally go towards, they may emphasize the continuity of unborn and born life, as Mr. Justice Humphreys mentioned in his recent decision, but they generally don't have much bearing, I think, on the question of what constitutional right, other than the right to life, the unborn might have, either under Article 40, Section 3, subsection 3, because of a wide reading of the term life, or else because there's some other provision of the Constitution that confers such a right. So the example, and Brian Murray will refer to this, I think, from another point of view in his paper later on. The specific area that's been litigated here is in relation to family rights, and particularly in the context of immigration. So basically we have a situation where we have a man who may or may not be married to the mother in question, but we have a man who is a non-national and is facing a deportation order or has had a deportation order made in relation to him. And his case is that the Minister for Justice and Equality, in deciding whether to make the deportation order or revoke the deportation order, is obliged to take into account the fact that he is going to become the father of a child once the child is born. So is the Minister obliged to take that into account? You may or may not be surprised to know that the Minister's position is, I'm not going to take that into account at all. I'll wait and see if a child is born, but I'm not going to anticipate that or try and speculate about what the future family rights might be in this situation. So there have been a number of cases here as to whether, if you have a woman who's pregnant at the time the Minister is taking her decision, and there's a man who's going to be deported, who's the father of that child with which she's pregnant, the Minister is obliged to take into account. Now, one thing to stress is the fact that the person concerned who's facing deportation is the father of a child is not an automatic protection against deportation. It's just a factor the Minister has to take into account and weigh. So the Minister might well say, no, I'm still going to deport you back to your home country because you don't have a sufficient connection with the country, or the mother and the child could go with you and live in that other country. So it's not an automatic entitlement to remain in the country, but the question is it a factor the Minister should have taken into account in reaching her decision about deportation? And we have three cases. Two of them say yes. In that situation where a woman is pregnant, the father, the future father, or the current father, depending on how you look at it, of her child, is entitled to require that the Minister give a reasoned explanation as to why his position as a father doesn't mean that deportation shouldn't be ordered in his case, because the child has a right to the society and care of his or her father when born. I suppose one thing to emphasize is that the first of those decisions, that point was conceded by the state. So the state said, we're not disputing that the Minister should have taken into account the position of the father, even though the child hadn't been born yet. The second case went very strongly against that position, the decision of Mr. Justice Cook in Ugbelase, and he said there basically the Eighth Amendment was very specifically focused on preventing deliberate termination of pregnancy within the state. He made the point, for example, that, as the judge referred to earlier, Article 40, Section 3, subsection 3 now consists of 3 sentences. And if you look at the sentence that the 13th Amendment put in relation to travel, he felt it would be anomalous to say that the unborn had a right to life which was sufficiently broad that it needed to be taken into account by the minister when making a decision in a case involving deportation, because in his view, if the pregnant woman can extinguish the life of the unborn simply by exercising her freedom to travel somewhere else, that indicates that the right to life of the unborn is really only focused on what happens within the state in terms of deliberate actions taken to terminate her pregnancy. And there's nothing broader there, there's nothing wider there that, for instance, the father of the child can rely on. The most recent and the most emphatic decision we've had is the decision from last July by Mr. Justice Humphreys, where he very emphatically disagrees with Ukbelasé. So you've got two High Court judges who disagree with each other very strongly. He's vehement in his criticism, I think it's fair to say, of Mr. Justice Cook on certain points. So he says clearly there's a continuity between born and unborn life. The minister has to take this family relationship into account between the unborn and his or her father. He also goes so far as to say that the unborn is an unborn child and is a child for the purposes of the Children's Rights Amendment, the current Article 42A of the Constitution. So he says, not only does the unborn have rights under Article 40, Section 3, subsection 3, the unborn has rights under Article 42A. It is natural and imprescriptible rights of the child that state guarantees to protect. His statement on that is a little bit undercut by him then acknowledging that, of course, Article 42A wasn't intended to have any effect on immigration proceedings. Article 42A is very carefully drafted so that it does not mean that the Minister for Justice and Equality has to take the best interests of a child into account in deciding whether to deport its parents. You'd be very surprised if the government had come forward with an amendment which did end up requiring them to take the best interests of the child into account. So it says in proceedings relating to custody of access, guardianship, etc. of the child between parents, in proceedings where the state is trying to take a child into care, in those proceedings, the best interests of the child are to be the paramount consideration. But the constitutional provision is defined very carefully, so that doesn't, at least explicitly, include proceedings about whether the child's parent ought to be deported, or whether the child's parent ought to be sentenced to a long period of imprisonment, having been convicted of a criminal offence, for instance. Another thing you could say, of course, is that really, in some ways, these cases could easily be reframed as saying they're not really about the right to life of the unborn in any meaningful sense, because even Mr. Justice Humphreys himself says that the irrational thing here is that the minister is ignoring what the situation is going to be in a few weeks or a few months' time. The minister is refusing to take into account the fact that in several weeks or several months there will be a child who has a family relationship with the individual who's facing deportation. So they could be seen in an administrative law context. They're really about what it's reasonable for the minister to say he or she should take into account in making a deportation decision. They don't necessarily derive from the rights the unborn has now at this point, given that the order that Mr. Justice Humphreys made in this case was framed specifically in terms of the minister having to take into account the likely situation that was going to come into existence once the child had been born.
John, we're running over.
I'm just on my summary here, yeah?
I know, and I just mentioned that there's likely to be an appeal.
I was just about to say that.
I thought you were.
There's likely to be an appeal, and indeed it may be an appeal direct to the Supreme Court in this case that Mr. Justice Humphreys decided, because it's regarded as a matter of public importance that it be determined as quickly and as definitively as possible whether he's correct on that particular point. So in relation to summarizing where we are, this is an area of great uncertainty, as Emily and the judge have already emphasized many of these topics are. There's a spectrum of views as to what Article 40, Section 3, subsection 3 does. You can read some judges, certainly, as saying that all it did was to copper fasten Section 58 and 59 of the 1861 Act as they were in 1983, and to make it clear that the courts couldn't declare them to be inconsistent with the Constitution, the Oireachtas couldn't replace them with some other criminal prohibition that allowed abortion in wider circumstances. Whoops. On the other hand, there are statements which fit more easily with the actual text that was put into the Constitution, that there's an acknowledgement of a broad right to life with much wider implications in situations that are removed, that aren't directly within that context. And really, we don't yet have a decision that clearly opts for one or other of those options or finds a place somewhere in between on the spectrum, because although there are statements that are germane to that or relevant to that in Roche v. Roche, they're not binding because they're not part of the essential decision the court had to make there. Because, to recap, all the court had to decide in Roche v. Roche was whether an embryo that was created outside a woman's body was the unborn or not. So that's all they did decide insofar as settling a question for future reference. Thank you very much for your attention.
Thank you very much. Thank you very much, John. That was very, very interesting. And once again, I would urge you to read John's paper, which gives a very good perspective on the difficulty of the issues. And he deals with the cases that he has referred to, and I think you'll find it very, very useful. As you will find Emily's paper as well. We're going to have a roundtable discussion now. This will be in private. We've overrun our time somewhat, so I'm going to suggest we finish the roundtable discussion at 11:25.
Conversation starters.
Oh, the conversation starters, yes. You'll see them on the screen, and the facilitators will have those, and they're also online in the interest of transparency, but they're just to prompt you, give you some prompts in relation to the discussion which will follow. And Sharon will say, yeah.
So just to clarify, just if for the first few minutes of your roundtable discussion, our two speakers are available to answer any points of clarification only. But just given that the timer for the discussion has been shortened, we just like to confine those as best you can. And just to remind you that we've asked the facilitators and note takers to take note of the key themes that are emerging from the discussion and note the questions that you'd like to ask on your behalf. Or as always, you can answer those questions directly. So it's just 20 minutes for this. Thanks.
Just give yourself that. And can I say that we've overrun time a little, and this will be slightly truncated. It will be for a 20-minute session rather than a 30-minute session. And that being the case, I would ask the questioners to be as precise as they possibly can be. So the microphones are in the room. Any hands up?
How are you doing? Dave, Table 12.
Yes.
A question for John O'Dowd. In the Roach v. Roach, the explicit question regarding the life of the unborn was decided on the basis that the fertilisation was occurring outside of the womb, so therefore it didn't come under the category of the unborn. If a similar situation was to occur in the courts where it was a natural implantation, conception, implantation, would that redefine the definition of the unborn potentially under Article 43.3 in the sense that it could, instead of actually being implantation, it could be argued that it would go back, as you said in the diagram, to an earlier stage of like the conception?
Well, that question, is this on? It is. That question's left open really by Roach v. Roach, but it should be stressed that a number of the judges in Roach v. Roach did express quite a clear opinion about that. And I think it's quite clear when you read their judgments in context that they did mean that the unborn only comes into existence when implantation takes place in the context of natural gestation as well as artificial reproduction. But as I was stressing, even if that's what they thought, even if that's what their opinion was, it wasn't part of the decision because that wasn't actually what they had to decide in Roach v. Roach. So that part of the decision isn't binding. What you could say is it gives a fairly good indication of what judges would be likely to decide if they agreed with those judges, if you see what I mean. There are lots of other areas in recent years in relation to assisted suicide or the question of who's the mother in a situation of surrogacy, where the courts have said, look, we're not going to determine that question because it's not really a legal question, it's a political matter. So that might colour, how the court would approach it as well.
Very good, thank you. Any?
Hi, I'm a member of the table here on table 13. And my question's for Emily. Emily, I just wanted to check, is there evidence or I suppose scope for Article 40.3.3 to be used during labour when you can't really go into a courtroom with a woman to perform interventions such as maybe a sweep, an ARM, an episiotomy without consent, and almost for midwives and doctors to operate on the principle of forgiveness, regardless of whether or not an unborn's life is at immediate risk?
Yes.
Do you understand the question?
Fully understand the question.
Yeah, I know. Well, perhaps just outline your understanding of it, just so we're not at cross purposes. That's what I'm concerned about.
I think what you're asking is whether or not Article 40.3.3 could grant a licence to perform certain procedures during labour, even where the fetus's the fetus's life is not at risk.
Yes, but also, I suppose, to allow them a principle of forgiveness to use these, is there scope for abuse of it in the delivery room?
Well, I think vis-a-vis the first part of the question, will Article 40.3.3 be used to licence treatments without consent where the life of the fetus is not endangered? I think the answer to that is no. Vis-a-vis the second question of whether or not procedures which are necessary might be forgiven, and by that I take it you mean forgiven in the sense of not viewed as either negligent or without consent or a breach of the mother's right to bodily integrity and autonomy.
If I may just interrupt you just for 1 minute, I'm more talking about maybe a case taken towards the NMBI or the Medical Council where a doctor has performed a sweep without a woman's consent, or a midwife has broken a woman's membranes without her consent. If she has explicitly said, I do not consent to this, will they be likely to face penalties, or will they be likely to be forgiven because the Eighth Amendment leaves it vague as to where they need to intervene? it's quite difficult to explain. I'm sorry, I'm not doing it justice.
I don't think the Eighth Amendment affects that situation, would be my answer.
Yeah. I mean, I think you're straying into medical negligence territory, which is a totally different terrain. Yeah.
Thank you.
Thank you.
Thank you, Judge.
Yes,
I'm the facilitator for Table 3. The citizens at this table had two questions. The first, indeed, Judge, you may need to add some comments to this, is when a case is been brought to the courts under 40.3.3, how are the judges selected? And the second question, or more of a comment, does the panel have any sense of how frequently we get a situation where the medical condition of the mother raises questions of whether she accepts or rejects medical treatment, which in turn has an impact on the fetus? Thank you.
Well, I'll deal with the first aspect of it, how judges are selected. It's not a question of selection at all. It's a question that you're, say in the High Court, you're assigned to a particular list. I used to do the Chancery list in the High Court, and it depends. It depends on the nature of the application. It could be an application for an injunction, in which case it would come to me. It could be an application for judicial review, in which case it would go to the judge dealing with the judicial review list. It's just happenstance, really, and perhaps the judge dealing with the list will not be in a position to deal with it, and he'll assign it to one of the other judges dealing with the list. So there's nothing of significance about the choice of judge who deals with those sort of applications. It depends on the nature of the application and who is dealing with the list on that particular day.
If I may just intervene. There is a difference here between the Irish situation and the one in England, because in England they have a court of protection, of course, so they have a very specialised judicial function there where judges deal. They have a much larger volume of cases. So in cases where you're dealing with the interests of the unborn or the interests of people with capacity issues, there's actually a dedicated kind of judicial core there. So maybe that colours some of the decisions they make in London because they have greater expertise and experience in the area.
And I'll just make one other point. There was mention, John mentioned, or Emily, or both perhaps, the PP case. That was perceived as a very, very important case that needed to be dealt with urgently. And in fact, it was heard, I think, on St. Stephen's Day. And it was a divisional court. It was a 3-judge court. Mr. Justice Kearns, who was the president of the court at the time, and Miss Justice Baker and Miss Justice Costello. But sometimes, if the issue is very, very important in the High Court, there is a divisional court, and it's dealt with urgently. But as I say, they dealt with that case on Christmas Day or St. Stephen's Day. It's probably St. Stephen's Day, actually. But there's nothing peculiar whatsoever about the way a particular case ends up with a particular judge. If that's the implication of the question, I don't know. And what's the second question? I've forgotten.
It was the extent to which situations arise where the mother's where the health of the mother and her decision to either accept or reject medical treatment impacts on the fetus.
I suspect that's maybe a practical question in the sense of how often does this occur, and without trying not to answer your question, I think to an extent really that's a matter for the medical profession. I suspect it occurs, in fact, much more often than we lawyers are aware, but that in many cases it's capable of being discussed, considered and resolved. Certainly insofar as how often it comes to court, it is vanishingly rare.
Anybody else?
Hi, I am a citizen on table 10, and we all have this question here. It's either for Emily or John, or both. Has a father any rights in relation to the life of the unborn here in Ireland?
Well, the cases we've had so far have been, as I was trying to stress, were about fathers trying to take advantage of the right to life of the unborn, where the mother, was quite happy to continue with the pregnancy, and so there was a child going to be born in the normal course of events, and he was just making a case that it was irrational to ignore the fact that he was going to become a father in short order. We don't have any case law on whether fathers have any kind of veto over a termination taking place. When the 13th Amendment was introduced, the 13th Amendment says nothing in this subsection shall limit freedom to travel between the state and someplace outside the state. A number of people, like the Labour Lawyers Group, said this is actually deficient because it's just saying that the right to life of the unborn doesn't prevent the woman having freedom to travel outside the state. What about the right of her husband in particular, if he's the prospective father of a child? And I think the argument there was, if you're saying that the right to life of the unborn doesn't outweigh her freedom to travel, how on earth could her husband's right to be a father surely the right to life of the unborn must be more important, if you think it exists, than the father's rights. So if you're saying that the unborn's rights don't prevent her from exercising her freedom to go outside the state, how on earth could you then uphold the putative father's right to veto the adoption? So I think in that context, that's probably the right interpretation of the 13th Amendment. So that casts a lot of doubt as to whether fathers have a right themselves. Now, as I think Emily pointed out, fathers could go to court and say, I have a special interest in upholding the right to life of the unborn because I have a special connection. And one of the tables asked me this question by way of clarification as to who's entitled to bring these cases. In the 1980s and 1990s, the Society for Protection of Unborn Children Ireland Limited were allowed to bring cases about abortion information, for instance, where they were saying that abortion clinics, students' unions, etc., shouldn't distribute information that would assist women to get terminations of pregnancy in England or elsewhere. And they were recognised as having standing to do that because it was said they had a bona fide interest and concern in the right to life of the unborn. They had a track record, they had an expertise, they were appropriate people to bring that action. But I'm not sure that would be the case if they tried to intervene in a case about a woman's medical treatment, for instance, and said, we are representing the unborn. So what the courts do typically is they appoint counsel to argue, the interests of the unborn. They don't let a particular party come in and assert the interests of the unborn. So a father might try to, become a party to such a case or bring such a case, but I think the courts might, and the father might be in a stronger position to make that case where it was about the treatment of a particular woman than some interest group would be. But I don't know if Emily has any comment.
I think maybe just to come in there as well, I don't think that there's an argument that the father of an unborn baby has any rights under Article 40.3.3. I don't think there is any argument that he does. The family law rights, the family rights might be relevant, but I would have thought that even if there is a family right in the father vis-à-vis this situation, it would be subordinated to the right to life or health of the mother, the right to bodily integrity of the mother, privacy, self-determination and so on, in a circumstance where one is considering a father's veto on an abortion. And then obviously if one were considering the fairly unthinkable scenario of a father trying to make sure an abortion did happen, clearly any rights that the father would have in that regard would be subordinated to the right to life of the fetus. So I hope that answers your question.
I mean, one thing one might add is that in Roach v. Roach, of course, the Supreme Court drew a very sharp distinction between the father there and the kind of father you were talking about, because they laid some stress on the fact that the father in that case was entitled to say, no, I don't want to become the father. I'm not giving my consent to the implantation of these frozen embryos. So that might be part of the significance of the distinction they were drawing, that he retained his right to, as one of the genetic parents, to have a veto and prevent the woman from having the embryos implanted.
I'll take one more question.
Hello, I'm the facilitator for Table 7, and a member at the table has requested the following question. If life ceases to exist when a person is deemed to be brain dead, does life begin when the brain starts to function, and at what stage of the embryo's development does this happen?
Well, as I was saying earlier on, the unborn isn't defined in Article 40, Section 3, subsection 3, and in Roach v. Roach, the judges do say that the unborn comes into existence, unborn human life comes into existence at the point of implantation, at the earliest, which is all they had to decide really on the most expansive view of what the issue in the case was. I think given the overall purpose of the Eighth Amendment, it's unlikely that they would find any later point and define that as when the unborn comes into existence. Because the purpose of the Eighth Amendment was, however you think it should be specifically interpreted, the overall purpose of it was clearly to say this is a human life, which is to be protected regardless of whether it's distinct, in some way from the mother's organism, or it has some independence, or certainly not whether it's viable or not. So I suppose you could say, yes, the idea of a brainstem, kind of emerging, the first signs of potential consciousness might be a dividing line, but I think it's unlikely. Again, as I've said, in a lot of cases in recent years on assisted suicide, on the question of who's the mother in the case of surrogacy, in relation to marriage equality before we had the amendment, the courts have said, look, these are not issues. We don't have any way of deciding this issue for you. It's a political question. So they throw it back to the Oireachtas and to the people in this case, and they say, don't expect us to draw a line for you as to what's permissible or not. So I think that means that in this case, they would probably just say, it is implantation, and we don't really have any basis for defining some point after that. To define it as implantation is to have like a clear criterion as to when it occurs, and if people are dissatisfied with that, then they need to amend the constitutional provision.
Do you want to add anything, Emily? Very good. Well, we'll stop at this point. I think what the members of the Assembly have learned from this morning is what a lack of clarity there is in the law in relation to the issues we've been dealing with. But I'm very, very grateful to both Emily and John for their presentation, which were very engaging, and also for their papers, which once again I would urge you to read and read carefully so that you get an overview. And really, I don't know that you can get much more than an overview of the issues. So thank you very, very much. Quick cup of coffee because we're starting again at 12. I never got the gong. Yeah, yeah. Oh, we have plenty, I think. All right, it's gone midday. We're going to move on to another topic, and my own assessment is that this is probably the most important legal topic that will have been presented to the members of the Assembly. It is extremely important. We're going to hear from Brian Murray, Senior Counsel, on the various options, and to use a neutralish word, that are available in terms of recommendations to be made to the Oireachtas in relation to the 8th Amendment. And I want to emphasise that Brian's paper, which will be on the website, is of the utmost importance in terms of the task the Assembly has been given by the Oireachtas. So I would ask Brian to take to the podium.
Thank you, and good afternoon. My concern in this paper is to try to consider with you a number of different possible scenarios regarding the position of the unborn within the Constitution. And in particular, I'm anxious to try and help you to understand the legal and constitutional implications of what happens if Article 43.3 is A, retained in the Constitution in its present form, B, simply repealed and not replaced, and C, amended in some form. And in relation to each of those scenarios, the critical question that presents itself is, what will the extent of the power of the Oireachtas to legislate in respect of abortion be in the event that any of those positions represented the constitutional situation? To do that, I'm going to revisit with you very briefly some principles that you have considered and have been considered with you in earlier papers, and to look again very briefly at the present position of the unborn in the Constitution and some of the legal observations that were made prior to the amendment of the Constitution in 1983, which, as we'll see, may be of relevance in assessing what happens if, in particular, Article 43.3 were to be repealed. Now, it's been explained to you already, and I'm sure you're familiar in any event with it, but just perhaps to outline some headline aspects of our constitutional system. The starting point is that it is the Oireachtas which is given the function under the Constitution of promulgating legislation. The effect of the Constitution is to constrain the ability of the Oireachtas to do that in a number of different ways by a number of different means. One of the mechanisms by which the power of the Oireachtas is limited is the provision within the Constitution of fundamental rights. The courts are given the power within our constitutional system to police legislation and to strike it down if they conclude that legislation impermissibly interferes with the rights of citizens. In that regard, the Constitution provides for a large number of express rights, rights to property, right to liberty, the right of the citizen to life, freedom of expression, freedom of assembly, to name just a few. The courts have also, and this is important in the context with which you are concerned, implied rights into the Constitution. The courts have decided that although not expressed in the Constitution, there are certain fundamental entitlements of the citizen which are inherent within it. And it is the courts which deduce and give effect to those implied rights. And again, importantly, for your task, the implied rights which have been derived by the courts of the Constitution include rights to privacy in general, rights to marital privacy in particular, rights to bodily integrity, and in certain circumstances, rights to autonomy, the right of a citizen to make his or her own decisions as to his or her own welfare and be able to give effect to them free from undue legislative constraint. Of course, the legislature is entitled to and regularly does impair rights guaranteed under the Constitution. But in order to do that permissibly, the legislature must have a good reason for interfering with a right. That reason can come in the form of broad considerations of the common good. It can come in the form of taking account of other competing rights. And the legislative restriction on a right must not be any more or go any further than is necessary to give effect to the objective. It's the role of the courts to make the decisions subtending those propositions. It's the courts which decide whether the legislature has gone too far in interfering with rights of citizens. It's the courts which decide whether the reasons for impairments are justifiable within the Constitution. And in doing that, the courts take account of a broad range of circumstances, including the nature of the right, its importance, and the particular justification which the legislature has for restricting or interfering with it. Now, those propositions are abstracted and they operate at the level of general principle. In relation to the unborn, the present position, as you all of course know, is that Article 43.3 provides express protection for the right to life of the unborn. It was inserted, as again you know, into the Constitution following referendum in 1983 and subsequently altered following subsequent referendum. But before 1983, the courts had given some consideration to what the constitutional protection of the unborn was in the absence of an express provision to that effect. And you will see in the paper, paragraphs 9 to 12, a number of statements made by judges in the course of deciding cases in which they had expressed the view that the right to life of the unborn was protected by the Constitution, although not expressly provided for therein. And perhaps the clearest and most emphatic such statement comes in the form of a decision, single judgment of the Supreme Court in the 1995 Abortion Information Bill, Article 26 reference, where the court said the right to life of the unborn was clearly recognised by the courts as one of the unenumerated personal rights which the state guaranteed in its laws to protect and, as far as practicable by its laws, to vindicate. Now, that meant that certainly there was a body of judicial opinion prior to 1983 that even though no express provision had been included in incorporated into the Constitution protecting the right to life of the unborn, that was nonetheless given effect to in a similar way to the manner in which other rights had been implied into the Constitution, although not expressly stated in it. But two important things about these statements. They were just that, statements. Lawyers distinguish between observations which judges frequently make in the course of deciding cases, where judges express a view as to how the law may develop, but which are not necessary to decide their cases. They distinguish between those statements and binding case law, where a court has to actually decide a question to resolve a case. So, prior to 1983, there had never been legislation which sought to make abortion more available than it was under the Events Against the Person Act 1861. Therefore, there was never a case in which the courts had to decide whether there was an implied right to life of the unborn. There were instead these observations. But nonetheless, there was a body of opinion prior to the Eighth Amendment that legislation which sought to introduce abortion or to enable abortion or decriminalise it in a circumstances broader than the 1861 Act would have been unconstitutional. The issue of whether those judicial statements were correct fell by the wayside once the people adopted the Eighth Amendment. There was now express provision in the Constitution providing for the right to life of the unborn. Now, this obviously is the backdrop against which you, the Assembly, will have to start to address what options are available to you. You've been asked to consider, to make such recommendations as you think fit, and to report to the Houses of the Oireachtas on the Eighth Amendment. Obviously, it's a matter for you how you discharge that remit. Nothing that I say here is intended to suggest any limitation on the range of options available to you. But what I do want to do is to assist in considering the implications of some possible recommendations. And in that regard, there are three obvious top-level options which the Assembly may wish to consider. One will be to retain Article 43.3 in its present form. And you have heard over the course of your deliberations a great deal of information regarding the legal interpretation of this provision, regarding its legal effect, and you know that the consequence of the provision is that the level of protection provided to the unborn by the Irish Constitution is extensive, and that the power of the Oireachtas to legislate in respect of abortion is limited by the protection afforded to the unborn. And you have considered the legal, medical, and indeed practical consequences of that. Those legal, medical, and practical consequences will continue to prevail as now in the event that the first possible option, retaining the article in its present form, is what finds favour with you. But there are two other options that you will wish to at least reflect on. Repealing Article 43.3, and by that I mean simply repealing it and not putting anything in its place, or amending it. And I don't believe that the second and third of those options have been considered with you yet, and it's for that reason that I propose to focus my comments on those. So, if Article 43.3 were to be removed from the Constitution and nothing put in its place, what would the consequence be? And in that regard, there are a number of important questions that present themselves. Would the position be that the Oireachtas was totally free to introduce whatever abortion laws it believed were appropriate? Would there be any constitutional limitation on the powers of the Oireachtas in that regard? If there was such a constitutional limitation, where would it derive from, and what would its effect be? What about the right to life of the unborn, which some judges had suggested before 1983 was impliedly protected by the Constitution? If the express right to life of the unborn were removed through the repeal of Article 43.3, would that implied right in some way revive? Indeed, were the judges who expressed that view, which again, to repeat, were not deciding binding case law and not making law, but were the judges who expressed that view correct at all? What about the right to privacy and autonomy of the woman? If the express right to life of the unborn is removed from the Constitution, then is there a prospect that the courts would decide that there was now no constitutional justification for having restrictions on the ability, entitlement of a woman to an abortion, save in limited circumstances? And you will be aware from earlier papers that in other jurisdictions, most noticeably and controversially in the United States, the Supreme Court there derived from a right of privacy, which, as the Irish Supreme Court has done, was found to be implied in the federal Constitution of the United States. The Supreme Court there found that there was a right to an abortion, frequently referred to as the right to choose. Is there a prospect that the repeal of the Eighth Amendment would have that effect? Now, the resolution of those questions depends on many of the general principles that I outlined at the start of the paper. Essentially, it comes down to this. If the Eighth Amendment were repealed, and if nothing put in the Constitution in its place, and if the Oireachtas introduced legislation allowing for abortion in a broader range of circumstances than is presently permitted, two prospects present themselves. One is that those who believe that the legislation allowed abortion too freely would come to the courts and say, well, the Eighth Amendment may have been repealed, but remember, there was an implied right to life of the unborn in the Constitution before 1983, and we believe this legislation, broadening the circumstances in which abortion is permissible, we believe that this legislation violates that implied right to life of the unborn. Or alternatively, there may be those who will say, well, this legislation does not allow for abortion in a sufficiently wide range of circumstances. This is an impairment of the right to privacy or decisional autonomy, or possibly the right to bodily integrity of pregnant women. At present, cases of either of those kinds would fall to be resolved by reference to the text of Article 43.3, there is a formula of words in that provision by reference to which the courts can, and as you know, have determined the balance between the right to life of the unborn and the interests of the mother. But if the provision is taken out, how will that balance be fixed, and by reference to what considerations? This is a matter on which different people have different views. And I think that one can reduce the possible consequences to three broad headings. The first would be an interpretation whereby the form of abortion legislation after repeal of the Eighth Amendment would be exclusively a matter for the Oireachtas. And on this version, the argument would be as follows. The people, were they so to do, have voted to repeal the Eighth Amendment. By doing that, they have made it clear that they do not want the Constitution to regulate abortion, and they want the decision as to when abortion will and will not be prohibited by law to be made by their elected representatives, not by the Constitution. And lawyers arguing for this construction or this outcome would say that the courts must give effect to the decision of the people to repeal the Eighth Amendment by allowing the Oireachtas a broad remit in formulating and passing laws regarding abortion. And the decision of the people, having had an express right to life of the unborn in the Constitution and decided to take it out, the decision of the people could only be that they do not want there to be any such constitutional regulation going forward. And were that view to prevail, two things would follow, I think, from any repeal of Article 43.3. First, the Constitution would not protect any constitutional rights of the unborn, or at the very least, whatever residual protection there was, would not prevent the introduction by the Oireachtas of laws which it deemed appropriate, enabling or regulating abortion. And secondly, on this view, the Constitution would not protect any right of a woman to an abortion. On this view, any form of constitutional regulation would have to be expressed by the people. So, if that view were to be correct, the consequence would be that following the repeal of Article 43.3, it would be solely the Oireachtas that would decide the form of abortion laws. The Oireachtas could decide to leave the law exactly as it is in the 2013 Act. It could make abortion available in a wider range of circumstances than is currently the case, or indeed it could limit further the circumstances in which abortion is available, even beyond the circumstances defined by the 2013 Act today. The point being that that decision would have been moved from the Constitution to the Oireachtas, the elected people, representatives. So that is one view as to the effect of the repeal of Article 43.3. But there's a second view, which would be this. Others will say, well, all the people have decided to do is to repeal Article 43.3, and different people who have voted in favour of that have done so for different reasons. Therefore, the argument would run, the implied right which the unborn had to life under the Constitution before 1983 revives. If the people had wanted to remove any implied right to any implied right to life of the unborn, then on this argument they should say so. And that if they don't say so, the presumption is that they are simply taking the constitutional position back to where it was in the early 1980s, which, on this argument, included an implied right to life of the unborn. So, if the Eighth Amendment were to be repealed, and if this argument were to find favour with the courts, the consequences would be most uncertain. It would be said that the Oireachtas, in introducing legislation to allow abortion, would have to have regard to the implied right to life of the unborn, and in some sense balance this against any judgment made by the Oireachtas that abortion should be more freely available. And that could limit the right of the Oireachtas to legislate freely to make abortion lawful in a broader range of circumstances than is presently permitted. One possibility in this circumstance is that the courts would try to strike a balance to say that the people clearly did not want the regime as provided for in Article 43.3 to continue, that's why they repealed it, but that not having stated that the unborn were to have no rights, that the consequence is that the courts should engage in a balancing exercise. The courts should try to conduct a balance between the circumstances in which abortion legislation should be permissible and the continuing right, if such it be, of the unborn. And there's then a third body of opinion, which would operate something like this. In Article 43.3, there is an express right to life of the unborn. That is the consideration in the Constitution which justifies the criminal prohibition on abortion. If you remove that provision, the consequence is that there is no countervailing circumstance to balance against the right to privacy or decisional autonomy, or for that matter, if it arose, bodily integrity of the woman. And therefore, those rights would generate what is in effect described as a right to choose. And if that were to be correct, then the entitlement of the Oireachtas the entitlement of the Oireachtas to legislate restricting abortion would be itself significantly constrained. So, those are the three options. Different lawyers have different views as to which of those outcomes is the most plausible. I personally think that the first is the most likely. I think that it most likely, were the amendment to be repealed, simpliciter, that the courts would decide that they should give effect to the view of the people, and that the consequence of the repeal was to extract, the consequence of the repeal, is to extract abortion regulation from the Constitution altogether. But that is only a personal view, and there are others who have different views. None of the positions that I've just outlined is impossible. Some are more plausible than others. And what it means is that if a proposal to repeal the Eighth Amendment is put to the people and no further amendment is provided for, there are likely to be different views expressed as to what exactly the constitutional position will be following such repeal. There are many who would be happy to have such decisions entrusted to the courts, and there are many who feel that they would wish a greater certainty, and those are some of the issues with which you will have to grapple. But remember also, and this follows from the papers you heard earlier today, repeal has implications potentially for issues other than abortion. You've heard two papers on various issues related to the Eighth Amendment. emphasising, I think, the uncertainty of the law, and in particular as to whether this article in the Constitution has implications outside the arena of abortion regulation. If Article 43.3 does imply more rights for the unborn, other than the right to be born, and if Article 43.3 does affect medical decision-making, these areas of law would also be affected in some way by the repeal of Article 43.3. If the effect of the repeal is to widen the circumstances in which abortion is available, greater legal attention would have to be paid to the issue of who gets to decide whether to have an abortion, whether the mother or both parents or the parents of a pregnant minor. And this picks up on a number of the issues you've heard discussed earlier. So, those are three possible constitutional implications. As I've said to you, different people have different views as to which are the most likely, which are plausible, but it's hard to say that none is impossible. And that leads to the next general option, which is not repeal of the Eighth Amendment, but to an amendment of it. And here there's, I think, a very broad range of possible amendments that one could conceive. But it seems to me that there are perhaps four principal types of amendment and one option related to or similar to amendment, and they're as follows. The first, of course, is to amend so as to increase the constitutional protection of the unborn, and that's an option which one would adopt if one felt that the protection provided by Article 43.3 in its present form was not adequate or not sufficient. The second would be to amend so as to allow more freedom to the Oireachtas to permit abortion by law, but only to do so in defined circumstances. And under this option, what the people would be doing were they to proceed in that way would be to maintain the right to life of the unborn in some shape or form within the Constitution, and thereby continue to limit the power of the Oireachtas to legislate in the area, but by defining within the Constitution a broader range of circumstances in which abortion is permissible, it would become possible to allow the Oireachtas, if they decided so to do, to alter the substantive law in the 2013 Act. And obviously, just how broad a range of those circumstances, that range of circumstances would be, would depend on the assessment of whether, and if so, when and in what circumstances abortion should be permitted. But what is important to emphasise about this type of amendment is that the Oireachtas would not be free to define the circumstances in which abortion is permitted. They would be specified in the Constitution itself. There's a third option, which would resolve the uncertainty attending the effect of a repeal of Article 43.3, and that would be to remove Article 43.3 in its present form and to replace it with a provision that expressly removes the right to life, or any rights for that matter, of the unborn. So on this version, what you would be doing is saying, the people would be saying, we want not merely to take out Article 43.3 in its present form from the Constitution, but we also want to make it absolutely clear that any suggestions in previous judicial statement that there were implied rights of the unborn, which might themselves limit the power of the Oireachtas to introduce abortion legislation, that we do not believe that that should be the constitutional position. So that, as it were, an express provision removing the right to life of the unborn would achieve that, or be designed to achieve that objective. Second not unrelated but different option would be to state that the Oireachtas shall have full power to decide on the scope of permissible abortion. And there are various formulae within the Constitution where certain types of legislative activity are immunised from review by the courts. No law passed by the Oireachtas allowing for abortion shall be inconsistent with any provision of this Constitution, and so forth. But the objective being to expressly state that we are consigning exclusively to the Oireachtas the function of determining abortion law and policy hereafter. And then finally, this option. I've seen it suggested that if the government published legislation at the same time as a repeal of, or as a referendum for the repeal of Article 43.3, and if the people were to vote to so repeal the provision, that the courts might decide in future that abortion in circumstances other than those provided for in the published legislation was not permissible. And perhaps a possible outcome, in my view, to say the least, it's not certain that that could occur. But the same effect could be achieved by repealing, but providing in the Constitution itself for a detailed law regulating abortion, which itself could not be amended without referendum. That's unusual. It's a cumbersome form of constitutional amendment. It creates various but not insuperable practical difficulties, but certainly legally it is possible. So I hope you find those thoughts of assistance in your considerations.
Very good. We'll move on now to the roundtable discussion. You'll have until 1 o'clock when we will have our questions and answers session. Have we any prompts? We have certain conversation starters, as I say, prompts, and they're up on the screen. And also, if I could say to the viewers outside this room, I would strongly urge you to have regard to Brian's paper. It is very, very helpful. Thank you very much, Brian. Very good, very good. Yeah. We'll start on the questions and answers, and we have 30 minutes approximately left. Yes, and we'll take as many questions as we can in the 30 minutes. So, hands up.
Hi, I'm the facilitator for Table 6. First, feedback was the citizens at this table found Mr. Murray's talk extremely helpful, and they felt that it would have been helpful to hear from Mr. Murray earlier in the process. We have two questions, or the citizens have two questions. Paragraph 35 of your paper, the last line says, on this interpretation of the implications of repeal, it is possible that the courts could declare unconstitutional an act of the Oireachtas that makes abortion widely available. If you could give us a hypothetical example of that. And the second question is, with regard to the Amanda Mellett case, the EU indicated that we need to address our abortion laws. So regardless of whether we choose to repeal or amend, can the EU overrule?
I think it was the UN actually, but that's a small point.
Okay. Well, to take those in turn, the comment I made in paragraph 35 is in the context of an argument to the effect that the implied right to life of the unborn, which had been acknowledged by some judges prior to 1983, revives. So I'm talking about a situation in which the amendment is repealed, in which the Oireachtas introduces legislation which allows for abortion in a broader range of circumstances than is presently the case, and in which a litigant goes to court and says this is unconstitutional because the unborn has a right to life, and even though the Eighth Amendment was repealed, that right had been acknowledged as implied by the Constitution before the repeal. The Eighth Amendment, on this argument, didn't actually introduce a right to life for the unborn. It merely expressed something which was already there. So that's the context in which this argument arises, in which this statement is made, and it's important just to understand that. In that situation, you've asked me to give you a hypothetical, and let's perhaps take this one. Imagine you had, following the Eighth Amendment, the introduction by the Oireachtas of the lifting of the criminal prohibition in the 1861 Act, thereby allowing for abortion lawfully without regard to any temporal considerations, any trimesters, any point in pregnancy. Just take that example. It's an extreme one, but it's probably the best way of trying to explain in theory how the argument would arise. In that situation, and this is not unlike what the United States Supreme Court had to do in Roe and Wade, or did in Roe and Wade, the courts may well say, no, we are going to draw lines and identify particular points in time where the rights of the unborn become activated and outweigh other rights in the balance. So that's an example, and that is actually what the United States Supreme Court did without there being any rights to an unborn under their constitution, but that's a different context. And then the hypothetical changes depending on how strong these rights are, to the extent that if the unborn were held to have an absolute a right to life equivalent to that in the Eighth Amendment, then any expansion of abortion law beyond the present parameters would be vulnerable if that construction were accepted. And I've given you my view, which is that I don't believe that that is the construction that would be accepted, and I've explained to you why that is the case. But just bear this in mind. The reason I have that view is that I think the courts would ultimately have to say, look, if the people have taken out an express right to life of the unborn, it must follow that they intended to take out the implied right as well. That's the reasoning that I think would be followed. But I've seen other people, other lawyers say, well, maybe the Supreme Court wouldn't say that. Maybe they would say, if that's what you intended, why didn't you say it? If the people intended that the unborn would have no rights under the Constitution, they could easily have said it. And not having said it, you've left us, the Supreme Court, in a position where we have to engage in this balancing exercise, having regard to what the legal position was under the Constitution before then.
The members at table 14 has just asked me to table one question.
No, there was another question, the Mellet question.
Oh, sorry, I'm terribly sorry. I'll have to give shorter answers and then I'll remember all the questions. Mellet was a decision of the United Nations Commission on Human Rights, not of the EU, and that has no legal effect in domestic Irish law. It has an impact on Ireland at the international level. And unless I am very much mistaken, and I will be corrected if I'm wrong, when Eileen Barrington addressed this issue, she may have been asked a question very like that, and I thought the answer she gave was that if the people decided that they did not want to change the Eighth Amendment, then Ireland would have to go back to the UN committee and say, look, the Irish people have adopted this position because of their moral judgment as to the position of the unborn, and that must now be re-evaluated by the UNHCR. That I think is how that dynamic would work. But it's almost at a level that's outside my expertise because it's almost a diplomatic rather than strictly legal issue. But I would agree with her if I've correctly understood what she said in response to that.
Now,
14 and then 5.
Yeah.
The members at table 14 have one question for Brian. If the Eighth Amendment is repealed completely and all matters subsequently in relation to abortion, protection of the unborn are going to be dealt with by the House of the Oireachtas through legislation, are there mechanisms in place or can mechanisms be put in place to stop subsequent administrations just changing the law regularly, willy-nilly, as they go from one administration to another?
Well, the answer to that question is yes, but the mechanisms would have to be built into the Constitution itself. Because the starting position is that the Oireachtas is free to legislate in such manner as it thinks fit, subject only to the intrusion of the Constitution. And if you want, or if the people decided that they wanted there to be a fixed abortion law, if I can use that phrase, and it's not perhaps the best phrase, but if the people wanted there to be a fixed abortion law that could not be changed, then the way to do that is actually to make that law itself part of the Constitution, which I think was the very last option I addressed. That's a cumbersome process that has many disadvantages attached to it. I think, but legally or constitutionally it's possible, indeed legally and constitutionally, you, the people, can do as you wish with the Constitution, provided any changes are sanctioned by the people themselves.
I'm the facilitator for Table 5. Two questions arise from the table. The first one is in regards to the phrase, as far as practicable, contained within the amendment. Is this legal speak for something specific? If yes, what is that? If not, can legislation decide what exactly practicable means, or can it define the word practicable? The second question is in regards to fathers' rights. If abortion was made legal, does it mean that the opportunity of the father to defend the rights of the unborn would be lost?
Okay.
Thank you very much.
Just to take those in turn, insofar as the phrase "as far as practicable" is concerned, yes, I suppose it is legal speak in one way, because it's not a phrase that people would use in ordinary conversation. So in that sense, that's the answer to your question. But what it means is that it envisages a margin of judgment by reference to which the phrase "governed by" as far as practicable falls to be measured. So the state acknowledges the right to life of the unborn. It has due regard to the equal right to life of the mother. It guarantees to respect, it guarantees to vindicate and defend that right but the obligation is limited to what is practicable or possible, I suppose, or reasonably possible. And the object of that is to say that you have to, in any constitutional system, the courts and therefore the Constitution itself has to give what lawyers in another piece of legalese call a margin of appreciation or discretion to the Oireachtas, to Parliament, to go about its business and not to interfere simply because they have a different view as to how it might be done. And phrases like that mirror that sort of constitutional separation of powers almost. In relation to fathers' rights, I mean, the answer to that question, and I understand issues like that were touched on this morning, the answer to that question depends on the following, none of which are certain. One, do fathers have any rights in respect of the termination of pregnancy at all under the Constitution? Two, if they do, to what extent are those rights affected by Article 43.3? And three, if they do, in other words, if the answer to one is in the affirmative, then what would the effect of any amendment be? And I think you need to work backwards from those, because if you say, well, the Constitution is going to be changed so that it's made clear that the Oireachtas has a wide berth, if I can use that expression, in formulating abortion law and policy. If that's what you decide, well then fathers' rights are going to be, if they are present and protected, are going to be subordinated to that constitutional expression of the supremacy of the Oireachtas. If you simply repeal the Eighth Amendment, well then you leave matters more or less as they are, except that the express protection for the right to life of the unborn and express reference to the equal right of the mother are taken out of the calculus, as it were. So, but you have to start off whether fathers have rights at the moment in the area of termination of pregnancy. And I have to say, my view, and again, other smarter people may have different views, but my view would be that they do not. But as I said, others, I'm not even sure if that's what other people have said to you, but that would be my own opinion.
Thank you, Judge. I'm the facilitator at table 11. Some members at the table have asked me to ask two questions on their behalf. Question one, in Mr. Murray's opinion, what scenario would give Ireland a similar legal situation to England? And question two, if the desire was to repeal 40.3.3, would there be a need to amend the 1861 Act?
Well, in order to achieve a position similar to England, the first thing that is absolutely clear is that Article 43.3 could not stand in its present form. So it would have to either be removed or replaced. And to remove it would, I suppose, have the various potential consequences which I've identified in my paper to you. The securest way of allowing the Oireachtas to legislate in the same way as the English Parliament has done would be, the securest way would be to repeal the Eighth Amendment and stipulate either that the unborn have no rights or to stipulate that abortion legislation and policy is a matter for the Oireachtas and only the Oireachtas. That is how, as I see it, is the securest way of achieving that objective, because in the absence of those two steps, you will face the various arguments I've considered in respect of any such legislation were it to be introduced. In relation to the decision to repeal Article 43.3, would that mean that the 1861 Act had to be repealed? I don't believe so. I think the probability is, for the reasons I've explained, that the 1861 Act would and could remain subject, obviously, to the changes introduced in 2013, and it would then be a matter for the Oireachtas to decide if it wanted to introduce new legislation, I think.
Judge, I'm the facilitator here at Table 1, and one of the citizens has the following two questions. Since the Eighth Amendment was put in statute, has any circumstance arisen where the Eighth Amendment was unjustifiable, in your opinion? And secondly, would you trust the Oireachtas to legislate correctly in the event of an appeal?
Well, I'm not going to answer either of those questions. I suppose it's worth a try, but
yes, we go to table 3.
I'm the facilitator for table 3, and the citizens at this table have asked me to put 2 questions to you. First of all, if it is the recommendation of this Assembly that there be an amendment to Article 40.3.3, who decides on the wording of the article, and how does the Assembly recommendations influence that wording? The second question is, where is this implied right to life captured within the Constitution other than 40.33? In the pre-1983 environment, which articles specifically were deemed to have that implied right to life? Thank you.
Okay. I don't know, Judge, would you like to deal with the first question? Because
Oh, yeah,
that's more
well,
a procedural
yes,
one.
It seems to me that if we were going the recommendation of amendment route, I think we would have to specify what we would regard as the appropriate amendment. We can't just say amend, we recommend amend. We're going to have to go further than that. I think this is something I will discuss with the expert advisory group, but that's my instinct about it.
In terms of implied rights, I think it's important to observe this. When the courts imply a right into the Constitution, and there's even an issue as to whether imply is the correct word. It's one, and I think I referred to this in a footnote, which I'm using because it's convenient shorthand, but to infer from the Constitution a right. They don't actually look at a particular article and say, this is the one that it arises from. Usually, and maybe privacy is a very good example of this, usually what happens is that the courts deduce from a range of considerations within the Constitution, the fact, and this is not insignificant in terms of the derivation of the right to life of the unborn, the fact that the Constitution proclaims the state to be Christian and democratic, the fact that there are certain values associated with liberty, the freedom of people themselves, which is a fundamental constitutional value, although not expressed necessarily in those terms. The fact that and I'm just using privacy as an example, the fact that in Article 40.5 of the Constitution there's an express guarantee for the inviolability of the dwelling. My recollection is that even in the early privacy cases, the courts looked at the fact that there's references to secrecy in certain circumstances, even including, as I recall, the electoral circumstance, all of which come together to the view that there are certain values which are so fundamental that even though they're not expressed in the Constitution, they can be derived from it. And it's usually from a range of different articles and also from other constitutional instruments. Do other constitutional courts, other countries with similar cultures recognize particular values? So that's the sort of canvas that's used. So when you say, well, where do they get the right to life of the unborn from? Those judges who believed that it was there. Well, Article 43 itself has a right to life in it, although referenced to the citizen. And the view would have been taken that the nature of the state and the nature of the society which it had established was one which led to the conclusion that there was that protection. It's not really in any particular provision of the Constitution per se. It follows from the general guarantee of personal rights provided by the Constitution.
Good afternoon. Facilitator from Table 9. Questions, a couple of questions for Mr. Bailey from the citizens here. The first part of the question in regard to would the legal position in regard to the issues that we've been listening to here be clearer if the Eighth Amendment was removed altogether? And the second question, should the wording of the Eighth Amendment, and it was following on maybe from Tables 3's aspect in regard to the wording that might be used by the legislature in regard to putting the right to life of the mother paramount, acknowledging the right to life of the unborn as a secondary aspect, because the citizens here feel personally that that maybe is rather confusing and it leads to more issues than that it actually solves. We'd just like to get your views.
Just so I can understand the question, would the legal position, if the be clearer if the Eighth Amendment was removed?
Yes. Well, in other words, the whole idea of having the confusion that the, if you like, the Eighth Amendment causes in the number of judges and in the application of the law, and we talked about or listened to this morning regarding immigration, deportation, and so on. It doesn't seem to be a very decisive amendment in that it causes more confusion than what it solves. It was really to get your opinion on if we took it out altogether, first of all, would it make the legal process easier? Because it seems, again, to the citizens here, that before the 1983 Act came in, the situation was rather clearer.
Well, I think this arises out of the discussion we had this morning about the rights other than the right to life.
I see.
That's where it comes from, the IRM case and cases like that. Are there different rights?
Yes.
Yeah, other than the right to life.
Well, I mean, certainly, I hope this answers your question. The existence of an express right to life for the unborn makes it easier for it to be asserted that there are necessarily other rights in the Constitution for the unborn. And that in turn presents a range of possible arguments that lawyers may feel it necessary to deploy in particular cases, and I'm sure it was referenced this morning. The immigration context is one, for example, where that issue has arisen relatively recently. So the short answer to the question, I think, is that the existence of that express right in the Constitution makes those arguments easier to advance. And I hope that to some extent answers the question. If the Eighth Amendment is, Article 43.3 is removed, would those arguments still apply? Well, they would be more difficult to make, but how difficult they would be to make would depend upon what exactly replaced it, if anything. And I suppose we're back then to the various issues which I discussed in terms of possible implications of repeal in the course of my paper.
In a sense, in terms of our task, I think that is peripheral, really. That would be my view. Okay. Any more questions?
Facilitator for Table 8. One member here had a question in relation to the option of amending the amendment. In option C or D, is it not effectively repealing Article 43.3?
So,
Para 43.
So the question then is whether in paragraph, the option considered in paragraphs 36, sorry.
44, yeah. Is it?
Sorry, 44 and 45,
yes.
option 3.
Yes. So it's the options of expressly removing the right to life of the unborn and the option of stating that the Oireachtas should have full power to decide. And the question is whether is that not effectively a repeal of the Article 43.3? Absolutely, that's exactly what it is. It is a repeal accompanied by another provision which makes the effect of the repeal clear. in those respects. Okay.
Any other question? Yeah, just one point. I got a prompt. Sections 58 and 59 of the Offences Against the Person Act 1861 were repealed.
The
2013 Act, yeah.
That's why I said
I
as affected by the 2013 Act.
Yeah, so that's what we're talking about. Such offences were thereby created. This has been a most helpful session. I'm sure you'll all agree, and show your appreciation. I have no doubt that we will be resorting to this paper night, noon and morning on the next weekend. Thank you very much, Brian.
Thank you very much.
It's been very, very helpful. Now, we're starting again at 2:30, and you know that lunch is in the O'Carolan room. Yeah, yeah.
Then there, just bring time to
I think we'll start now. Now, this morning we concluded that part of our work programme that involves expert presentations. To date, our work has focused on providing you, the members, with the detail required to be able to make informed recommendations to the Oireachtas on the 8th Amendment of the Constitution. We have consistently tried to put this material before you in an objective and neutral manner. At this juncture, we should take a moment to remind ourselves of the actual words of the 8th Amendment as enacted, which we have been tasked to consider. And I've just quoted, although, as you know, it was quoted this morning, the state acknowledges the right to life of the unborn and, with due regard to the equal right to life of the mother, guarantees in its laws to respect and, as far as practicable, by its laws to defend and vindicate that right. That's Article 30, Section 3, Subsection 3, as originally enacted. As I mentioned this morning, there were additions as a result of the 13th and 14th Amendment. But in any event, what I want to emphasise is that the words I've quoted have affected people, both born and unborn, in Ireland, and in many ways, directly and indirectly. To gather many voices, views and opinions on the topic, the Assembly asked for submissions from individuals, representative groups, citizens' organisations and members of the public on the topic. As you know, we received over 13,000 submissions, and the remainder of this weekend will be entirely dedicated to information, testimony and opinions brought to us via the submissions process. When you are considering the many voices and opinions you will read, hear and engage with over the remainder of the weekend, it is very important that you place them in the context of the entire work programme that we have put to you to date. They also provide you with an opportunity to review and assess what you've heard in other sessions. This is a citizens' assembly, and as the citizens you have consistently asked to hear from the voices of women whose lives have been directly impacted by the 8th Amendment of the Constitution. This is important because these are very particular experiences that most of you will not have experienced yourselves. Personal testimony affords us an opportunity to hear firsthand about some of the effects of the medical, legal and ethical theory we have heard since we held our first meeting some months ago. In presenting this testimony and in making the necessary arrangements for it, the Secretariat and myself have been guided by several key principles, and I want to emphasise these key principles. First, that those who offer to share their stories are treated with sensitivity and compassion. Secondly, that the stories put before the Assembly reflect a range of perspectives and experiences. Thirdly, that the stories do not imply any judgment on the decisions made by other women in similar circumstances. And fourthly, that the testimony offered is informative and will aid you, the citizens, in your consideration of possible recommendations to the Houses of the Oireachtas. These are our guiding principles, but from the outset we must acknowledge that it has not been possible to capture everyone's lived experience. However, the circumstances covered today include those who had a crisis pregnancy and those who received a diagnosis of fatal fetal abnormality or life-limiting condition. Also, while every effort was made in terms of bringing you a spectrum of voices, it would be impossible to capture a comprehensive range of case studies. Rather, this is an attempt, and I emphasise attempt, to highlight the many and overlapping complexities involved in women's personal experiences with the Eighth Amendment. Given that the women involved were making submissions to the Assembly, whose job it is to consider the Eighth Amendment, it is unsurprising that they expressed their own views about the Eighth Amendment during the interviews. This is part of telling their story. It would have been very inappropriate for us to silence these women by censoring their views. However, it does mean that all of you, as the members of the Assembly, will have to think very sensitively and carefully about what the women say. I am sure that, like I was, you will be struck by these women's bravery and honesty, and will respect the integrity of each personal experience that is shared with you. But you may find that you draw different conclusions from each experience compared to those drawn by the woman herself. This is a necessary part of this deliberative process. One of the core values of this process is that we respect the perspectives of those with whom we may disagree. This also means that we can disagree with those whom we respect. This value becomes even more important today, tomorrow, and during our last weekend in April. It is important that at this stage that we discuss in some detail how we are bringing this personal testimony to you. The women who will share their story with you today were identified through the submissions to the Assembly, either directly or through a representative group. In making this selection, I first looked at women who wrote directly to the Assembly and who indicated that they would be willing to share their story with the Assembly. To ensure that a range of circumstances was presented, a representative group was in one case contacted to assist with the identification of women who might be willing to tell their personal stories. I was assisted in the selection process by the Secretariat, the HSE Crisis Pregnancy Programme, and with the academic support from the Crisis Pregnancy Counselling Skills Programme in Maynooth University, and I'm very, very grateful to all of them for their assistance. There is detailed documentation about the process on the website, and I would encourage people to visit these pages, and I believe it is a valuable record of both the complexity of this process and of the good faith that it was undertaken in. The interviews were recorded in February, and the testimony has been provided anonymously. The reason for this is that some of the women who have been interviewed sought anonymity. These are women who are telling their stories not as public figures but as individuals and private citizens, and we must respect their wishes. Therefore, in the interest of consistency, and I stress that, in the interest of consistency, each of the 6 stories will be presented anonymously on the day. Finally, I would like to take this opportunity to place the voices we will hear in the context of the submissions we've received. Over 200 individual personal stories were received by the Assembly, and many more were received via advocacy groups. The Secretariat has collated these submissions, mindful of all requests for anonymity, in one document, and Sharon is going to demonstrate how these can be accessed. This is a very important document. These are real-life experiences, and I would ask you, the members, and anyone who is following the Assembly, to assess the material. And Sharon will illustrate how this is done.
Many thanks, Justice Lafoy. Good afternoon, everybody. So the members have indicated that the Assembly should hear directly from women who have been affected by the 8th Amendment. To that end, the Secretariat has identified, to the greatest extent possible, all of the personal stories out of the 13,000 received through the submissions process. A list of these has been compiled and is available on the website to allow the members and the wider public to access and ease of access of these stories. In doing this, we've taken a very broad interpretation of what is meant by personal story. The majority of stories are personal testimony from women who have been affected by the 8th Amendment. We have also included stories received from partners, parents, grandparents of those affected, friends and others who have been affected by the 8th Amendment. It also includes some personal testimony from members of the medical profession who wish to share their personal experience with the Assembly. In many cases, those making the submission requested anonymity, and those wishes have been respected. In a small number of cases, the Secretariat has taken the decision to anonymise certain details. This is mostly where the story being told relates to a third party, and it's unclear to the Secretariat if that third party has consented to their story being told. Many of the submissions received from advocacy groups also contained extensive personal testimony from women. In many cases, those women chose that path to share their story as they had an existing relationship with that group and felt more comfortable sharing their stories there. In other cases, they include personal testimony previously compiled by that organisation. These submissions contain a wealth of experience, and all relevant organisations are listed in the document that I'm about to show you to help the members of the Assembly and the wider public access them. So these stories can now be found on the website, and I'm going to show you just for the sake of clarity, just because I want people to be able to access them. So this is the homepage of the Citizens Assembly website, and across the top you have a number of tabs, and there's this one here is submissions. So when you click on that, across on the side here you have a navigation bar which says submissions received, and when you click on that, there's a section here at the top describing advocacy groups and personal stories. And the first paragraph relates to the fact that at its meeting back in January, the citizens indicated that they wished the advocacy group submissions to be published out of chronological sequence and as a matter of priority. So we did that and made that list available to the citizens back in the middle of January. And that list can be viewed here, and I'll just open it up just so people can see. So that's the list of all the advocacy groups and representative organisations and groups essentially that have an interest in this area that have written to the Assembly. But what we've put up new today is this question of personal stories that the members have also requested that personal stories should be prioritised. And we were conscious that in order to search for them, because there's 13,000 submissions, we wanted to essentially shine a light on the personal stories. So the list is linked here, and it essentially provides, there's approximately 240 personal submissions. So the beginning of the document contains a description of essentially what I've just gone through there, and also tells you that the personal stories can be found on the website in 3 ways. Number 1 is where somebody has asked for their anonymity to be preserved, and in all of those cases we have described those submissions as name with Secretariat, and for shorthand NWS for search purposes. You can also search by using the person's name. In many cases, people have provided their testimony or provided their submission and included their name, so you can search for that submission by using their name, and then finally by searching the name of the advocacy group. So in this document you'll see there are lists of the name of the person, the submission title and the date, which should aid with searching. So there's a list, there's a number of pages there, and then towards the very end of the document we have the advocacy groups who've made submissions on behalf of women. So just going back to that, the page, then here is the list then beneath in the search bar where you can search for all of these personal stories. So I'll just demonstrate how by typing in NWS, which is name with Secretariat, and hitting search, that brings up all of the personal submissions that are there from people who sought anonymity. So there are about 100 of them. So if you scroll to the end, in some cases they contain attachments and so on. In some cases they have a title of the submissions, in some cases they don't. And across the bottom here you can see there are 10 pages of testimony of that nature, which indicates that there's over 100 submissions of that nature. So the thing to say about this is the Secretariat has tried to be as comprehensive as possible in compiling these lists, and the way in which we've done it is by reading them all and categorising them and putting personal stories. So it's not an absolute exact science. So in the event that we're made aware of any omissions, we'll update it. And if the list is updated, that will be provided to the citizens, and that list online will be updated for the sake of completeness. So I hope people have found that helpful. It's a very, very useful tool, we hope, on the website. That, together with the submissions from the advocacy groups, and indeed all of the 13,000 submissions that we've received, are up online now. Okay, thanks.
Thank you very much, Sharon. Now, just to continue, the interviews with these women were carried out by Dr. Mary Ryan, Head of the Department of Adult and Community Education and Co-Director of the Counselling and Adult Guidance Programme in Maynooth University. Sinead Inglesby, who is here today, was engaged by the Secretariat to undertake the logistical elements of the recordings. Dr. Ryan will provide you with some further details on the interview process before we begin. After that, we will begin, and the voice of a woman will be heard every 7 minutes. Each voice will be followed by a moment for member reflection, where the Assembly will go into private session for 3 minutes. Now, that's not to say that our observers have to leave, or the media has to leave. It's just that we'll pause the live streaming and the televising for the 3 minutes. Finally, I must thank all the women whose voices we will hear today in bringing their voices into this room, into the Assembly. We are engaging with real lives and with real lived experiences. These are women bringing their stories to us at our request to help us understand the 8th Amendment. I'm truly grateful to them. And I just want to make one other observation. I think Anne McCarthy is here, is she? And I would have told the members this morning that she's available if anybody feels the need for some assistance from her. I think she's at the back of the room. Yes, Anne, thank you very much. And then I am now going to call on Mary Ryan to give us some further background to the stories and to introduce each one. Thank you very much.
Good afternoon. First of all, I know they've been already thanked, but I would like to thank, on behalf of Sinead Inglesby and myself, and Sinead is there, to thank the women who so courageously and generously shared their stories with us. This was not an easy or straightforward process for the women involved, and provoked many memories, emotions and feelings. But while the stories are deeply personal to them, they're also universal. And they could be about our mothers, sisters, daughters, relations and neighbours. Maybe as you listen to the stories, they may remind you about similar experiences, and they may stir up strong feelings and emotions in you. We hope that this will not prevent you from listening and being present to the stories. While they may be emotional, they are quite normal as well. You may not agree with the decisions described in the stories, but even so, we would really like to encourage you to listen to them in an open and non-judgmental manner. So, just to kind of describe briefly the process Sinead and I used to carry out the interviews. Sinead contacted all of the women, and she had a detailed phone conversation with them initially, describing the interview process. She confirmed that their overall contribution would be edited to a duration of approximately 5 to 7 minutes. And she described the way it would be presented to you today. She made sure that all of the women were comfortable with the fact that ultimately their stories and testimony would be shared more widely than even here. She discussed the possible publicity that might arise following the broadcasting of their personal stories at the Assembly today. And this process of clarification continued at all stages of the interview and editing process. We made it clear to all of the women that they were under no obligation to continue with this process and that they were free to withdraw their consent at any stage. And all of the women were happy to proceed on this basis. And they could even withdraw up to 5 minutes ago, and they haven't. The interviews ranged from 35 to 70 minutes in duration. Each story is unique and individual. Each woman has a different way of sharing her experience, with emphasis on different aspects and details of her deeply personal narrative. The focus of the editing process was to outline each woman's personal circumstances and that of her decision and its impact on her life in a way that would be accessible to those listening. We also needed to ensure that it was reflective of each woman's overall conversation in terms of tone, emphasis, and opinion. Each of the women has had an opportunity to listen to the edited version of her interview in order to ensure that she feels that it's a fair and accurate summary of her overall contribution, and that she continues and is still comfortable with it being presented to the Assembly today. Each of the women has given full consent of their edited interviews to be so presented. In looking and being present and listening to the stories, a number of themes emerged from the stories. All of the women welcomed the opportunity to tell their stories to the members of the Assembly and hope in doing so that it will be of benefit to other women in similar situations. For some women, it was their first time to tell their story in public, and they saw Sinead and I as representing Irish society and the Assembly. All expressed a need to discuss their concerns about their pregnancy and explore all options in a supportive and non-judgmental setting. Each story is different and complex, shaped by a unique context and time. All of the women feel they made the best decision possible at the time and in that particular context. So, what we've decided to do is that we will play each story and give you a period of 2 to 3 minutes after the story, just for you to write down your reflections before we go into the new story. What you write is confidential to you, it won't be shared, but you might speak out of it later. And what I'll do is draw time at the end of the 2 to 3 minutes and we'll go into the next story. So, I'm going to tell you the first story. The circumstances described in this first interview happened within the last few years.
I was at a wedding. It's a family friend, drinking obviously all day. Girl meets boy, girl goes back to hotel room, consenting adults, use protection, but it obviously didn't work. I suppose it was a few weeks later I wasn't feeling 100%. Because we had used protection, I didn't think I needed to go to get the morning after pill. So I kind of didn't think anything of it. And I'd been in the house with my mum and her friend turned around and went, "God, you look great, you're glowing." And I went, "Oh shit." In my head, I said, "Right, I need a pregnancy test. I have to go and figure out what's going on." I didn't want my mum to know. So I did the pregnancy test in the public toilets on my own, and it said 2 to 3 weeks, and I just went, shit, what am I going to do? And the first thing that came into my head was an abortion. I can't have a child. I'm not ready. I don't have a partner. I have a job, but it's not a stable job. I can just about support myself. I still live with my mother. Like, I didn't want a child for a start.
So absolutely clear from the start.
Oh yeah. The minute I found out, I was like, termination, not keeping. My mind didn't process that I would keep it.
Some people would say, well, if she had been able to get a bit more support, or if she'd been able to think about it, she might have made a different decision.
No. Categorically, no. One of my sisters lives in London, and she'd actually bought me flights for my birthday to go to London.
What was it like for you those days?
Awful, really awful. I just didn't want to be pregnant at all. And it's one of the hardest phone calls I've ever had to make. I had to ring my sister and I had to say, I'm pregnant.
Yeah.
What do I do? And she said to me, you're coming over anyway. We'll get it sorted when you're here. It was just strange knowing that I was pregnant and I didn't want to be pregnant, which was the main thing for me. Luckily enough, I had my friend who was there to support me. Like, I would have been lost without her. She was great. As far as my mum was concerned, or my sister or whatever, I was going for a holiday. Nobody knew apart from my sister and my friend. And I remember sitting on the plane, and the one thing that was going through my head was, if this plane crashes, everyone's going to know I'm pregnant. And I just didn't want that whatsoever. It was the last thing that I wanted. I don't know if it was just that people would be disappointed in me, or I'd let people down. I really don't know. I just felt bad, and I was pregnant and I just didn't want to be, because it was a one-night stand, and I think that's probably where I would think some of the judgment would come in.
And the other party to this one-night stand, did they know?
No.
You've never told
No.
them?
As far as I was concerned, it was none of his business. It was my body, it was my choice. It never came up in my thinking. I suppose I was nervous, anxious, just wanted it to be over with, really. But yeah, I remember sitting in the waiting room and feeling anxious, because obviously I'd never had a termination before, so I didn't know what was the protocol. So then I went into the room and they examined me again, and I was worried at that stage they were going to say, we can't do it, and I was going to go, well, you have to do it, because I'm only here for a week and this has to be over and done with by the time I go home. But I remember there was 2 foreign girls, and one of them had a leaflet in her hand that said abortion. So I knew that's what she was there for as well. So I think in a way that made me feel a little bit better, because I knew I wasn't the only one. I couldn't tell you how long it was before the cramping started, but it got fairly severe. It was quite painful, the cramping. So they had said to me that you will pass the clot, but you might see it. So I actually think I did see it, because there was quite a large clot in the toilet at one stage.
And when you saw that clot, what was the feeling?
Relief, possibly. Glad that it was gone. Knowing that it would have worked, I suppose, yeah. Wasn't pleasant. It's painful, and the fact that I projectile vomited and, felt nauseous and had major cramps in my stomach. So I basically was just in bed. To a degree, I was one of the lucky ones that I had somebody that I had a bed to sleep in, and that I didn't have to sit on a plane and come home. To go through that on a plane must be absolutely horrific, and my heart goes out to anybody that does it. It was difficult for me, but I think that has to be 10 times worse. Or even a hotel room has to be bad as well. At least I had the comfort of knowing that I had my sister and it was her home, so there was a homely feeling to it. I think the cramping must have stopped at some stage. I couldn't tell you whether it was that night, whether it was the next day. It's a bit of a blur. It was strange knowing that I'd been through the procedure the day before, but kind of acting as if nothing had happened, because life just went on. I think it was around the anniversary of when I'd had my termination that my sister told me she was pregnant, and I just I went to pieces. I was happy for her, but it just brought everything back for me that I was like, this time last year, I was pregnant. I don't know whether it was just after that or whether it was a couple of months later. I decided I needed counselling because I hadn't dealt with it, because everything was pushed down. I boxed everything off. My counselling then was also disguised as something else because I couldn't tell my mum that I was going to counselling now for my abortion. I'm in a better place, but I think to this day I still feel exactly the same way as I did then. That I don't regret it at all. It was the best decision that I could have made for me. Occasionally it would come into my head, I could have a child, but it's a could, it's not I should, I wanted. For me it just wasn't an option, whether I had the support or not. It's a tough thing to go through, but as I said, I don't have any qualms about what I did. There is still a lot of secrecy within Ireland about it, but I definitely think my counsellor helped a lot with that. The secrecy thing, the judgment thing. Speaking to somebody and know that I wasn't being judged and being able to tell somebody else so it wasn't a secret again.
So, before we go into the next story, just if you take 2 or 3 minutes on your own just to write your feelings about that. Again, it's confidential, you won't be showing it to anybody, but just where you're at having listened to that. It doesn't need to make any sense, but just, if you can, just write, how has that impacted on you? And sometimes the writing isn't to make any sense, but it's maybe to just to say a word, just to hold some of your emotion and feeling. So, because sometimes what I find is the voices will blend and you'll forget what you felt. So even just a word to capture how you're feeling. So if everybody could come, oops, sorry. That's what you do not want. I was trying to be so careful. Okay. We'll now move on to the second interview. So, the circumstances described in the second interview happened in the early 70s. And you're just going to hear her now.
In 1970, I was going out with a young man, I would have been 19, and discovered I'm pregnant. It was the only time I'd ever had sex, and got pregnant obviously straight away. I just went into total panic, couldn't think clear, couldn't eat, felt so ashamed, couldn't tell my best friend even, more or less locked myself in my bedroom, hoping and wishing it would just disappear or it was a mistake or something. He said, "Oh, should we get married?" I wasn't at that point where I wanted to get married, or I didn't know whether I wanted to marry him. I remember going into town one night and standing on O'Connell Bridge thinking, it'd be better if I was just dead. I couldn't kill myself. I hadn't the courage to do that, so the only other choice was what he was saying, we'll get married. And there was no one to talk to. It was like I was in a little bubble, in my own little world. I wasn't functioning right at all emotionally. I just pushed it down in a way and just focused on we're getting married and trying to pretend to everybody that this is what we had planned, and we'd worry about the baby shown later on. I remember going into Holles Street, and even going in there I just felt like it wasn't really real. I was like looking in through a window at somebody else having this situation. It wasn't really me. I didn't understand anything that they were telling me. I had to tell my mum and dad that I was pregnant, and my mother was just screaming, crying. How could you do this to me? You can understand the shame for a family. She had to face her sisters and family and my grandmother, and she had to face all the neighbours. So there was this charade put on that I'm getting married, and it was all about the wedding. And I was so sick, vomiting. I couldn't get on a bus. I couldn't, everywhere I went I was getting sick. I think part of it was the stress. The fear of having the baby then was, as time was getting closer, like the fear of the actual thing. I couldn't even think where were we going to live or what was going to happen, when we got married. I can remember going into one of the classes in the hospital, and they actually showed us a birth. And oh my goodness, I was so frightened. I was so scared, and I was crying and crying. The nurse was saying, "You should have thought of this 9 months ago. Don't be crying now." There was no compassion. You made your bed, you lie in it now. Once she was born, then people's hearts melted. My mum and dad were doting over her, and it's forgotten, the shame. It's like you're forgiven then. They did look after me in the end, It was as much a shock for them. They didn't know how to deal with it. They hadn't ever thought anything like that would happen to them, so they weren't prepared for it. But it was really hard going. The tension in the house was, even though they were helping me, it was stressful for my mum trying to cope with another baby in the house and crying all night long, and she'd start crying, I'd start crying, and there was tensions in every situation. We eventually saved enough money for a deposit on a house with the help of my parents, but the relationship between us was never good. And he started suffering with depression and wouldn't get up out of bed and go to work, and he had a lot of issues that I didn't realise. And so we were fighting, and I ended up looking for a separation. And so I spent 11 years in and out of the Bishop's Palace looking for an annulment. So there was years of trauma after the marriage as well. Yeah, it was tough going.
And the option of abortion wasn't there?
No, it wouldn't have entered my head in those days. I never heard of it. But I think had it been part of our society, part of our structure, of course I would have. I'd have been straight there under the stresses I was under. And my child wouldn't be here today. And look at those two precious grandchildren. The joys you get. It's hard, but it's doable, and you recover. It hasn't been easy, but I would hate to think where my life would have gone had I had abortion and having the guilt of that. especially when you realise later on that this was a real baby. It wasn't a fetus, it was a real baby. I'd always be wondering what my child would have been like. I just think there's so many more choices nowadays. If you're pregnant, you can get so many supports. If you just want to keep your baby, you'll get housing, you'll get income. And there's life after the baby. They grow up so quickly. And I think it made me the person I am today and gave me a different kind of education. Thank God that the society I lived in didn't provide that. I'm so happy they didn't provide that, because it would have been an easy option for me to save the shame and nobody has to know, and you could just have your life back again. You know, when a baby comes into a family, it just brings so much joy to everybody. There's nothing like a new baby. It was a gift. She was a gift. You know, I didn't know it in the stress, but if you give life a chance, it brings amazing joy. And I think if people go and have abortions, you don't know what regrets they might have later on and what damage that might do to them. In the early months of pregnancy, your hormones are all over the place, and it's very hard to make a good decision when you're in that place. And I think a healthy society that loves and values life needs to be embracing and supportive and support the mother and the child. I just thank God that I didn't have that choice. I can't imagine my life without her or without my grandchildren. There's so many positive options to not getting on that boat or plane and doing that, because there's no recovery from that. You know, I just wish people would give life a chance, I suppose.
So I'd like to thank the woman in that interview, and again invite you to take 2 to 3 minutes just to jot down where you are after listening to that. It can be a word, it can be a feeling, it doesn't have to make sense. Confidential, and it's for you. okay, if you can be coming to an end of your reflections on story 2. We're now going to listen to voice 3. And the circumstances described in this third interview happened over 15 years ago.
I was only 18 when I had my first child. 14 months later, I had a second child. I was after falling pregnant on my first pregnancy on the pill. I was after falling pregnant on my second pregnancy waiting to get the injection because you can't get it for 6 months after you have a baby. Went to get it, I was pregnant again. So I had 2 small babies with only 14 months between them. Unfortunately, I was attacked, very violently, sexually assaulted by a stranger. That was very difficult. I developed agoraphobia. I developed an awful lot of anxiety, and we were left to deal with the fallout of that really on our own, trying to raise 2 small children. I started coming out of it and come back out into the world and try and find my feet again. And I was taken off the injection by my doctor because I'd been on it too long, so I had to give it a break. While we were waiting to get the next contraception, I fell pregnant again. I was only starting to stop having daily panic attacks. I was only getting a handle on my mental stability. And I had 2 babies that had already suffered. They'd already basically watched their mother have a nervous breakdown. So finding out I was pregnant again was terrifying. Terrifying because I didn't think I was mentally capable of looking after another child, and financially they were equally as scary. We were already financially struggling. We were a one-wage family. We just couldn't afford. How would we look after the 2 that had already suffered? You know, they didn't deserve to be denied more. You know, we had a 2-bedroom apartment. Where were we going to put another baby? Bringing another baby into an already stressed family doesn't make things better, it makes things harder. As much love in the world as you can have for a child, you still need to provide. We both didn't want another child. We both knew that it was the right decision not to have another child. We sat up many nights, long into the early hours, discussing everything. I'd already given up my carefree years to have children, and I didn't regret that. I love my 2 children deeply, but I knew it wasn't the right decision to have another child, that I couldn't mentally cope with another child. I was just about beginning to breathe, and I was just beginning to see my own worth. And having a child is one of the hardest things that anybody on this planet will ever do. Being responsible for the happiness and health and well-being of another individual. I already knew what was required to do the job properly. And at that time, and since then, I know I didn't want to do that job again. Once I had come to terms that it was the right thing to do, then the process of trying to get money to go to Liverpool began, and that was 6 weeks, ending in us getting a loan from a loan shark. It's unbelievably expensive. You have all the flights or ferries, taxis, bus connections, whatever it is, you have accommodation, you have the price of the procedure, it's not cheap. My procedure happened a lot later than it needed to happen. It was so stressful. We had to take out this ridiculous loan with ridiculous repayments. My 2 children, knowing that we were coming back to that was horrific. I was so ill. I was just vomiting. Nearly every time I moved, I was getting sick. I lost weight. I felt like I couldn't even visit my GP, because how could I visit my GP, be being sick, be morning sickness, but I wasn't keeping this baby? I felt like I would be shunned out of my doctors and struck off their list. There was no one here in Ireland that could give me an answer as what the repercussions would be if I went to a doctor. I was terrified, absolutely terrified. At the time, I felt like everybody knew. Even on the ferry, felt like the staff knew. It's that big taboo and you feel like you're on that boat with a big shiny bloody cone, alerting everybody to your shame that you're just dirty woman being shipped off like trash, like you don't deserve to be looked after in your own country. We're just going to ship you across the Irish Sea and let somebody else deal with your mistake. Even though you know you're doing the right thing, you're still ashamed. And I don't think that's right. I don't think women should be constantly made to feel that shame. It's not our shame. Why should we be threatened with 14 years in jail because we don't want to add to our family? Men can choose to walk away, but women can't. This is my body. I had a right to do whatever I want with my body. I done it for my 2 children that deserved every chance that I could possibly give them. I believe that the decision I made benefited them, that they deserved a sane, functioning mother. And if I had have had another child, I don't think I would have coped because I wouldn't have been able to find me, to figure out who I was apart from just being a mother. And I think I make a better mother now that I have my own individual identity. I had them very young, so it stunted my individual growth, and I didn't need to have another child. I needed to find out who I was and develop myself as a person and heal myself. I couldn't go through any more stress and add any more stress and pain into my life. I had to start the healing, and this was going to send me back to turmoil again. There was nothing left in the tank. It was the right decision, definitely, for my family and me. After the abortion, I went to college. That gave me lots of confidence. I still suffered with panic attacks, but I coped with them. My natural baseline personality was able to come back out and resurface itself, and I found who I was. Even though I knew I'd made the right decision, there was still this weird shame. I've been called a murderer. I've been called Hitler. I've had terrible things said to me. I'm not a murderer.
How would you like to describe yourself?
Responsible. Hopeful. That I made the right decision to make the people that were living and breathing in my life a happier and healthier family. We're not ogres. We're not unclean. We're your sisters, or your mothers, or your nieces. We're every woman. Enough is enough. We need to take this shame and stigma away from this.
Again, to thank that woman for her interview, and again to invite you in the next 2 minutes just to jot down your reaction, a word, just to see where you are after listening to that. And this is our fourth story. It happened in the last few years, and after this story we'll have a break.
I'd arranged to have a 12-week scan, and I actually remember skipping into it. The midwife was scanning us for over an hour. She kept getting me to get up and move and jump around and drink water, and then was saying the baby was very quiet and not really moving. She went through our blood results and explained that some of our blood results were very worrying. Together, her with another doctor had said that it was either triploidy or severe placental insufficiency, but they'd never seen a baby who presented as our baby was live past 16, 17 weeks, and we'd most likely have an imminent miscarriage. At first, we were hoping that they were wrong, and every week we'd come back and I'd ask the doctor, did it still look like she was going to pass away? And every week he would tell me that she was going to pass away at some point during my pregnancy and that she would never be born alive. I suppose as the weeks went on, it got more and more unbearable because I thought she'd pass away by 16 weeks and then 18 weeks, and then at 18 weeks we got our results of all our tests, which confirmed that she had full triploidy, which meant that she had a complete extra set of chromosomes. They said that variant of triploidy is always fatal. There was no hope. When I was 24 weeks pregnant, I remember thinking, how can I be pregnant still with my baby who is going to pass away? Walking into the hospital and you'd see everybody else with bumps and carrying these car seats with their babies, and realising I was never going to be leaving the hospital with my baby in a car seat. My baby's going to be leaving in a coffin, but I still have to come here every week. And I'm still pregnant, and I remember thinking, why am I still pregnant? They said as long as there was a heartbeat, they couldn't induce me. And even if I was at 40 weeks, they couldn't induce me, so that they would leave me go to 42 weeks and let it happen naturally. I really wasn't sleeping, I wasn't coping at all. My blood pressure started to go up, and they had said to me that I was showing signs of early preeclampsia. It made me feel like I didn't matter. My life was the same as like a non-viable baby. But then it looked like they were prepared to let my physical health and my mental health really deteriorate at any cost for a baby that would not live. I had this dying baby inside me, but it felt like I was dying as well. And it felt like neither of us were getting the care we needed. We'd sent all our files over to Liverpool. They didn't believe, well, it was fair on me to force me to continue with the pregnancy. They also didn't believe that it was fair to force a baby to go through birth who couldn't survive it. If a miracle happened and she did survive labour, that she would have a fit and die instantaneously, but that it would be painful and distressing, and that their medical opinion was that it was kinder to put the baby to sleep, that they won't feel any pain, and then induce labour. And I think that was the first time I felt that let it happen naturally wasn't actually the best way. And that as a parent, if I went abroad and chose to have an abortion, that was actually caring for my daughter. Part of the problem with the Irish system is that I felt the medical professionals couldn't speak freely. I never really knew if the advice they were giving me was what they thought was actually the best advice, or if it was the only advice that they could give me. It was frightening, and it also felt like I couldn't really come to a decision as what to do, because I felt I needed to talk openly and freely with an expert so I would understand everything about my decision. That could be also why we spent so long waiting and not travelling. I was frightened. I didn't want to leave Ireland and travel. I didn't want to have to lie to people and tell people that I'd had a miscarriage or that I'd had a stillbirth. Probably because I loved her so much. I didn't want her to be associated with an unwanted baby. I remember talking to my daughter and telling her how sorry I was. That I wasn't strong enough to continue with my pregnancy. And I was so sorry she didn't get to meet her grandparents and my sister, and that we had to leave. But I'd felt continuing with the pregnancy was putting my physical and mental health at risk, and that it wasn't going to change the outcome. And I was lying in bed at night having nightmares about her being born and not being able to breathe or having fits, or was she in pain? We decided to go, and then everybody in Liverpool being so kind and compassionate to us, and seeing that the care they were giving us, that we could be giving our women, and that we're choosing not to. Not all pregnancies are going to have a happy ending. Women will need to end their pregnancies. When she was born, she looked perfect, but it's very small and very fragile. And they had said that for her dignity, it would be better to leave her and have her cremated. It meant that when we came home, we couldn't have a service for her for another month until we got her ashes. That is another layer of grief that going away has added. It was like, go away, have your baby, come home. And it never happened, and it did. I didn't think my home would abandon me like that. I still miss her, I still wish that we could have had her, but I can manage my grief now. And I'm so grateful that I have a healthy, happy 1-year-old. But the thoughts of getting pregnant again fills me with such dread and such fear. I feel like I would be putting my life in danger. I feel like I have carried a pregnancy with a non-viable diagnosis, so I know what it's like to continue with the pregnancy. But knowing what being trapped in a pregnancy that I felt I wasn't able to be in feels like I don't think it's right to force any woman to continue with the pregnancy if they feel that they can't.
So I'd like to thank the woman for sharing her story with us. And again, just to invite you to take 2 to 3 minutes just to jot down or record how you are. Where does that story sit with you and leave you?
We can now move on to voice 5. Yeah.
So we have 2 remaining stories to hear. And just again to remind you that while we were very clear with all the women, the conditions under which the interviews would be heard and edited, the content and what they chose to speak about is entirely their choice. So we're now going to hear story 5. And the circumstances described in this interview happened 10 years ago.
We were going for our first scan at 22 weeks. We were very excited to be pregnant, a very wanted little baby. It didn't take the midwife long at all to spot that there was something really not right. She said, "This is not good news. This baby can't survive for long outside the womb." But she had to go off and get the obstetrician to come and confirm and give us the official diagnosis. He was able to say to us that our little boy had anencephaly, that at any time from now on he could pass away. 80% of babies with anencephaly are born alive, and that therefore there's a high percentage chance that he would be delivered safely, but then it would be a certainty that he would die shortly after that. You can continue the pregnancy, you can go to England for a termination, and that would involve an injection into his heart through my stomach to stop his heart, then inducing labour, and I would have to deliver him dead for certain. How I felt at that moment was, he's safe in your womb, versus I could go somewhere and allow somebody to inject his heart with something that will end his life. It started to dawn on me, I have no choice about losing this child. He's going to die, but I have a choice about his life in between, and I have a choice about getting to know him. I have a choice about allowing him to live his life and giving him what I can while I have him. And I'm his mother. I have what it takes to mother this child. We had made the decision by the time we'd left. His life, which we thought was going to be stretched out before us, is now this size, but we can make the most of this. And we can give him everything now. Once we'd made our decision, he assured us that while you're with us here, we will treat and value you and your baby as 2 valuable patients to us. I think for a mother who's just found out her child is so vulnerable, to be assured that strength of, we're there for you and your baby, you are both valuable, I think that's what any mother would want to hear. Dealing with news like that is a process. It's such a blow and it takes time. I found myself tossing and turning that night, having nightmares, and then waking up and going, oh, the nightmare was real. Just that sense of, I can't get away from this, and just wanting to run. And then remembering, that's right, it's not going away. We are going to lose this little boy. But he's here. He's not gone away. In the end of the day, what do I want? I want to know him. I want to give him all the love I can give. And actually, as the acceptance sank in more and more, then embracing the new situation was able to happen. Over time, the joy of having him today and in this moment grew. Waking up in the morning to his kicks and his punches was like, oh, there you are, you're here, able to talk to him every day. And actually, that was an extraordinary gift. They always allowed me an extra long listen to the heartbeat, and his heartbeat was always so strong. I felt so proud of him for this strong heart he had. It was also fear. I remember coming towards the labour. I found as I got closer, I got more just uncertain and anxious, and what was up ahead was just so unknown. It was 36 weeks. I went in having contractions. Actually, this was the first time I'd met this midwife, and she saw my chart and she goes, now, you do realise that this child is incompatible with life, don't you? I felt like she'd kicked me in the stomach, because this was something she was discovering for the first time. This is my son, and I've been living knowing this for weeks. His heart is beating and he's alive. How can you call that incompatible with life? The contractions started to kind of slow down again, and I was starting to get quite frustrated, and I was going, why am I so determined to get on with this? This is the beginning of the end of our journey. This is okay if this takes time. It was like I took him by the hand and I said, however long you take, that's okay with me. I just relaxed completely then, and I just felt so much more peaceful. We want to be there for our children for as long as they need us, but also be always letting them go as they grow up and move away from you. That's our job as parents. And actually this is no different, it's just really intense. When he was finally born and in our arms, he was so beautiful and yet so vulnerable, so perfect and so imperfect, both. But I remember just gazing upon him and feeling two things. One, just wanting everything for him, wanting him to be whole. But two, utterly loving him just as he was, and the completeness of being able to together, myself and my husband, tell him we loved him, kiss him, hold him. And when he died, he just slipped away so quietly. We had gone as far as we could go with him. I had been there for him. I had seen him, I had met him. I had been bowled over by the beauty of who he was, and now I could let him go. So there was just a piece about that, which I think for me has been just an anchor in grieving afterwards, because as you can imagine, the horrible pain does come. Like, there's nothing nice about grief. It's awful, and losing a child it's horrendous. I have a face, and I have memories, and I have memoirs, and we just take out his memories and we look at the photos, we talk about him. There's just an openness in our grief. When I look back now to that moment when we were given that news and the two options that faced me, I just feel for me, I would always be wondering, what if I would have met him? What if he'd lived longer than I realised? What would he have been like? I feel very grateful that I have that freedom in my grief. During the pregnancy, learning to live in the moment, that's kind of a lasting impact he's had on me. He's taught me to be more merciful to myself, to learn to be generous to myself, and to have patience with myself. Even a person who maybe on the outside looks like they can't survive, they're, in the terms of that midwife, incompatible with life, somebody like that can bring such a treasure into a family. I've been finding myself feeling so upset of late when I see babies being quoted as headless monsters. And also then mothers like myself being misrepresented as forced to carry around dead babies. That babies like this are the reason we need abortion here. I just feel like the whole understanding of a life like that is being lost. And I feel so upset when I hear of parents who've had to travel to England to have a termination, and just the awful circumstances around that, and having their babies sent back to them in the post. That's just horrific, because all these babies are so wanted and so loved, and yet that is because of a culture where a life like that is not protected by law and is not valued by law. And that's why that happens in that country. And when I think of the time it took for the reality of the news I'd heard to sink in, and for me to be able to get my head around what had just happened, going back to that moment, you are so vulnerable. You need to be minded, you need to be cared for. I cannot imagine what it would have been like if abortion was available, where I didn't get a chance to think through that, and where the doctors who I trusted were saying to me, this is medical management of your pregnancy. We do a termination, don't look at it as an abortion. I might have lost my son within a week. I would hope that babies would continue to be valued both by law and by us as a nation.
So I'd like to thank the woman for her story, and just to invite you in the next 2 to 3 minutes just to take some time to jot down what's left with you after listening to that story. It can be a word, serious words. And so we come to our final story, the sixth one. And the circumstances described in this interview happened over 15 years ago.
I was diagnosed with meningococcal septicemia in 1999. I was 4 months in hospital, very unwell, and the recovery took about a year, and I was on lots of medications. I had a boyfriend, and we were only going out a couple of weeks. I was on the pill, and we also used condoms. The night that the condom broke, I was also aware that the medication that I was using could undermine the pill, so I was really worried. I went to a family planning clinic to speak to somebody about getting the morning after pill, and they said, you're not going to get the morning after pill unless you get a referral from the Rape Crisis Centre. And that wasn't the context of why I had been there. So I got the train from Galway to Dublin, I got the train from Dublin to Belfast. It was really, really stressful. Anyway, I get the morning after pill, and then I thought that was it. had nothing to worry about at that point. I'd covered all my bases in terms of my protection. And then 3 weeks later, I do a pregnancy test and it comes back positive. My world absolutely fell apart. My family were very conservative and I was afraid of the shame I was going to bring on them. They were just trying to recover themselves from my illness from the previous year, and they were worried that I wasn't going to survive. So the last thing I wanted to do was bring another drama on them about this crisis pregnancy. Like many of my peers who've been in the same situation, I went to them first because I didn't know what to do. The only information at the time is crisis pregnancy organisations. And I thought I can go in there and they can direct me on all of my options. And at that point I'd already decided I really wanted to have an abortion. I could see my whole future laid out for me. I was being offered a job, and these are all the opportunities I was going to have to turn down if I went forward with the pregnancy. And also I was concerned what damage the pregnancy was doing to my body as I was still recovering from the meningitis. I was really hoping for somebody who was going to be sympathetic to my situation and give all of the information that was not possible to get. I knew my contemporaries were going to England to get abortions, but I wanted to know, who do you call? How do you book it? She said, but you do realise your baby has a heartbeat now. I was like, this isn't a baby. This is a group of cells. I'm only 5 weeks pregnant. And she said, you know that in this country that having an abortion is illegal. If somebody discovers that you've had an abortion, you could go to jail for 14 years. And I was told that in what was supposed to be a counselling situation. I kind of felt I was in a total shotgun situation. And I also felt really guilty as well. I thought, oh my God, I've been so selfish. I'm not thinking about this baby. I've been thinking about me. Now, having that perspective, I just feel that was complete manipulation of the situation that I found myself in. I was very, very vulnerable, terrified. I mean, 20 years old, no information available to you. So I remember leaving the office feeling utterly even worse, I think, that actually a judgment had been made against me. So I rung my aunt, who had lived in England for 20 years, and I thought, she's going to know what to do. She was brilliant, and she told me about Marie Stopes, and she told me how much it would cost, and she said she was going to come with me, and oh God, actually having that was brilliant, having somebody just to say, you're not alone. But I think for me the damage had been done by that conversation with the counsellor, because I think a seed was planted at that point, and what I ended up being more worried about was people finding out that I was pregnant and I had done something about the pregnancy. I was worried that somebody would say something to the guards. So in that fear, I made a decision to continue on with the pregnancy. I eventually told my mother. My mother was really adamant, you're not allowed to go to have an abortion, it's a sin. We won't be able to look at you again. If you make that decision to go to England, then you won't get the support that you need here. But if you go the other way, we will offer you the support with the baby. The boyfriend at the time was unwilling to deal with it. As I went forward and had the baby, I ended up on my own because he was unwilling to be there to support the baby either. The health concerns did actually manifest in the pregnancy. I had the baby when I was 7.5 months because my liver went into shock, so the baby was premature. I loved him. I can tell you I loved him from the moment I saw him, and I loved feeling him kick inside me in the same way that since, and I've had other children, I have loved those babies. But what I do not like about this whole thing was that decision about being pregnant and living with the consequences of all of that was forced upon me. And there was no access to information to get another alternative. And the decision that I made going forward and having my son did ultimately change the trajectory of my whole life. I ended up having to come out of college, working minimum wage jobs. I was on housing lists. All of my choices became really, really limited really quickly as soon as I had him. Whereas I look at the other person that created him, and he had nothing holding him back. I'm 37 now, and I look back at all of my 20s when all my friends were travelling the world or progressing into education or into employment, and I was queuing up to get a one-parent family payment, or somebody was calling on the door to investigate whether I was conning the system or asking questions about my private life. A judgment was put on my whole life. I had to live with all of these consequences. Any sense of privacy or dignity went out the window when I had to make that choice. I mean, I just think of, the founding document of our proclamation was cherish all the children of the state equally. I didn't feel cherished. And I'm a child of the state. I was totally and utterly othered by my constitution, by the legal system, by access to information or access to progression as a human. And then you're not allowed to talk about it. You're not given any kind of platform to say, hang on a second, there's no equality here. That makes you feel very isolated and angry. It's not that I regret having him. I absolutely adore my son. I'm very happy that I have him now, but I do feel that a huge opportunity was lost by being forced to make that decision. It's about choice. It's about actually somebody trusting you and really listening to what your fears are and saying, that's a really valid concern. And are you sure that that's what you want to do in life? Okay, well, if that's what you want to do, and I accept that decision, and I'm going to support you in that choice, and I'm going to be there for you afterwards when you've made that choice. Going forward, what I would really like is my country to be aware that there's another 50% of the population here, and how can you make them feel cherished?
So I'd like to thank that woman for sharing her story with us and asking you again just to take a final 2 to 3 minutes just to jot down the impact of hearing that story in you. It may be just a few words, might be a sentence, but just to hold something of the experience of listening to that story.
At this stage, on behalf of the Assembly, I would like to thank each of the 6 women for the testimony they have given us here today. I'm conscious of the fact that some of them may be listening at home to the proceedings here, and I want to be sure that they understand how much we appreciate their contribution to us. I can assure them thank you very much. That it does really show appreciation, and I think it's appropriate that we should show appreciation. I would also just remind the members that they should retain their reflective notes, and they may be of use to them. I suspect they will be of use to them in the future. We're now going to go into a private session during which there will be round table discussions in relation to the 6 interviews we've just heard. Following that, there will be about another 10-minute reflective period, and once again I would suggest to the members that they record their reflections, and this recording is all for themselves, so that when we get around to dealing with the recommendations, they will be able to look back and remind themselves how they felt this afternoon. We'll resume the public session at 5 p.m. and I can assure everybody that the closing remarks will not be too long. Thank you very much.
nicht diese Töne, sondern lasst uns angenehmere anstimmen und feuertrunken himmlische dein Heiligtum, deine Zauber binden wieder, was die Mode streng geteilt. Alle Menschen werden Brüder, wo dein sanfter Flügel weilt. Deine Zauber binden wieder, was die Mode streng geteilt. Alle Menschen werden Brüder, wo dein sanfter Flügel weilt. Wie der große Wurf gelungen, eines Freundes Freund zu sein, der ein holdes Weib errungen, mische seinen Jubel an. Der auch eine Seele seinen auf den Erden rund, und wir stiegen von der Stille, weinen sich aus diesem Grund. Freudet wiegen alle Wiesen an den Brüsten der Natur. Alle Guten, alle Bösen folgen ihrer großen Spur. Kenntnisse gab sie uns und Reden, einen Freund geprüft in Tod. Und uns hat den Mund gegeben und den Herrn steht vom Mund. Kenntnisse gab sie uns und durch des Himmels prächtigen Land laufen Brüder eure, und laufen Brüder eure, wann freilich wie ein Held zum Siegen, wie ein Held zum Siegen, laufen Brüder eure, Deine
Hi everybody. Just to say, we've come to the end of our time for the discussion, so we're now going to ask the... I'm just going to double check something, sorry. Yeah, so now we're going to ask the facilitators and note takers to leave the tables, and we're going to do the individual reflective exercise, which I think is at the back page of that sheet that you've been working off. And we'll all start singing So Long Farewell or something. So just to thank all the facilitators and note takers for today.
It's going to be cúpla focal. I promise that. But just a few observations I have to make. First of all, I just want to remind you that the description we had in the agenda, what we described what happened this afternoon as first-hand experiences. And they were first-hand experiences. We heard the voices of real women. We heard the voices of real lived stories and experiences. I just want to absolutely emphasize that. So I also want to tell you, which I don't think we've told you previously, that while in the interests of consistency, we decided that all of the speakers would speak anonymously. We have made it clear to all of the speakers that if they want to speak to the media now, they can do so. And if they want to abandon the anonymity, they can do so. But the objective in sticking with the anonymity was to ensure consistency. But we're not putting any constraint on any of the speakers in relation to anonymity, none whatsoever. So I just wanted to make those two things clear. And now I will express my thanks once again to the 6 women. We're very, very grateful to them. And I would also like to express my thanks to Mary Ryan and Sinead Inglesby for the great job they did for us. I know you all have had a very hard day, and we have an awful lot coming tomorrow. So what I want to do is I want to encourage you to relax this evening and to get yourself built up for tomorrow. I hope to see most of you at 6:45 this evening. And we'll resume the public session tomorrow, and we have a very early start. We're starting at 9 a.m. and I'll see you all then at 9 a.m. in the morning. Thank you very much.